the fence rests, let's lay it down. Gonna dig deep, wave that verdict round. The defense rests, time to analyze. With the evidence, we'll unveil the crime. Justice served in an honest fight, true crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule at the defense rests.
Indicate that justice may not be done if the trial continues to a verdict, and I think to constitute a mistrial, the conditions complained of must constitute an irreparable injustice that couldn't be cured by a jury instruction. I think when you apply that standard, as I've outlined in my written order, I don't think that the circumstances currently before the court rise to that level of prejudice that would constitute the need for a mistrial. Obviously, defense, if you want to put anything on the record at any point, expanding on your motion or your argument, I'd be happy to allow you to make that record when you feel the need. But thank you. You're welcome. All right. So moving forward, in terms of the motion to dismiss, I think it's most appropriate that we simply defer that and take it up at the standard time for a motion to dismiss at the end of the state's case, which we will do when the defense presumably makes their argument at the half. So I'm going to defer ruling on that. In terms of the request for the missing witness instruction, I have reviewed the case law in New Hampshire on that matter. I've reviewed some federal case law on that. I have looked at particularly at Massachusetts case law, which I find particularly instructive. And having reviewed all of that case law, I am not inclined to grant a missing witness instruction in this case at this time. And I'm going to explain why. I mean, I think when you read all that case law together, it is pretty clear that the complaining witness in this case is in the state's control, as that term is normally used, meaning that the complaining witness is most closely aligned with the state, would be most likely expected to testify on behalf of the state, that the state has better access to the complaining witness than the defense does. And so even though, and the case law makes clear that the question of availability is more limited to the question of, can you locate the witness and bring them to court? And I think in those terms, I think the witness is available. But I do think this witness is in the state's control, as that term is used. But I think the reason I'm not inclined to grant the missing witness instruction is when you read the Massachusetts case law, and in particular, I'm most struck by looking at Commonwealth versus Salatino, which is 449 Massachusetts 657. That's a 2007 case out of Massachusetts. And Commonwealth versus Figueroa, 413 Massachusetts 193. That's a 1992 case. Both of those cases make clear that the missing witness instruction is most appropriate in circumstances where a witness who is in the control of one party, who has material evidence and would be expected to testify, is not called without explanation. And that, I think, that factor or that element wasn't really discussed at the hearing yesterday. Salatino makes clear it's when the witness is not called without explanation. And in this case, the state has offered an explanation as to why it does not intend to call Mr. Violette in this case. Particularly, the state discussed the witness's unwillingness to testify, the emotional stress that the witness was under, the fact that the state, having prepared this witness, made the decision that it did not think it could put this witness on. The mere fact that that's partly a strategic or tactical decision does not take it outside of that analysis. And if you read Salatino, And I also point out, Salatino makes clear that a missing witness instruction should only be given in clear cases and with caution, because it is such a potentially devastating instruction to give the jury. So, but Salatino says the missing witness instruction is appropriate when a party has knowledge of a person who can be located and brought forward, who is friendly to, or at least not hostilely disposed toward the party, and who can be expected to give testimony of distinct importance to the case, and the party, without explanation, fails to call the person as a witness. And in Salatino, the court goes on to say that the instruction should not be given where the Commonwealth has a legitimate tactical reason for not calling the witness. And if the circumstances considered by ordinary logic and experience suggest a plausible reason for the non-production of the witness, the jury should not be advised of the inference. And I think that is the case here. There is a plausible reason, a legitimate reason why the state has chosen not to call this witness. And in that circumstance, I don't think that the adverse inference would be warranted. And so I don't think it would be appropriate to give the instruction to the jury that they can draw that adverse inference. I'll also point out that the law in New Hampshire is clear, as well as in Massachusetts, that the missing witness instruction is discretionary. The court has discretion to grant it. Neither party can demand it as a matter of right. And that I think the denial of the request for the missing witness instruction, I don't think rises to a constitutional level of a due process violation. So for all those reasons, the court is not inclined to grant the missing witness instruction in this case. And so that's where we are at this point. All right. And obviously, again, defense, if you wish to make any further record on that point, you're welcome to, and we'll give you an opportunity when you would like to. Thank you. All right. So with that, I think we've resolved those preliminary matters, and my plan was to go ahead and have the state call its next witness, which was the police detective, and then we would move forward.
We have an issue on for the court concerning the scope of that testimony, Your Honor.
Okay.
Next witness is, we're all aware, is Detective Garston, who did, among other things, the interview of the defendant on the night immediately after these events. There is a body cam image of it, and there's also a full transcript of it. The state intends to proceed by transcript for reasons of efficiency and also notions of redaction. It is easier to proceed with the transcript because it's the state's position that certain aspects of the statement are not admissible. But a brief conversation with the defense concerning that. In fact, I brought it up before trial, but we've revisited it now and continue to have a disagreement on it. And it's this: the defendant in this case, when he was explaining the events of that night, also made reference to a prior event from approximately 2 months preceding this event, where Mr. Levesque claimed there was a verbal altercation between the defendant and the victim, where he alleged that the victim called him, quote, a rat for calling the police on him, and again threatened him and, quote, his family. He didn't do anything as a consequence of that in terms of like calling the police or anything. He said he had no intervening contact with the defendant and couldn't pick him out of a lineup. Saw him maybe between those previous 2 months act and this event, saw him maybe take out the trash. Wasn't even sure if he lived there. And yet now, apparently, they intend to seek the admission of that to advance the self-defense claim. The state's position is it's not admissible. I reviewed State versus Newell. Unfortunately, we are still at a loss, technologically speaking, and I don't have a copy of the case. But nevertheless, I'm familiar with the holding and the principles of it, which is that, and by the way, it's cited in the notes to 404 and 405. It comes down to this, that the defense, in my view, if they wanted to introduce this, should have filed a 404B motion just on the threshold of relevance for another issue besides propensity, even concerning a victim. Had the court even ruled as a second step that it was admissible, it's constrained by the admissibility requirements of 405. 405A deals with relevant traits, and 405B deals with relevant elements that would be subject to evidence concerning peacefulness or aggression. In this instance, we're talking about traits, so it's limited to opinion testimony, and only the opposing party can cross-examine then on issues of specific instances. If it were an essential element, the proponent of the evidence could introduce specific instances, but in State versus Newell, our Supreme Court concluded that peacefulness or aggression is not an essential element of self-defense. It may be a relevant trait, but that would then be constrained by 405A. Again, this all presupposes that there was an appropriate 404B motion to actually tease out, to examine for the court to assess the actual evidence concerning the claim. We haven't gotten there, but even to the extent you're able to take a look at the transcript, the state's position is it's not admissible under 405B.
Attorney Sisti?
Thank you, Your Honor. I appreciate getting this vetted right now. A couple months prior to this event, Jason did have contact with the alleged victim in this case. The reason we know that is because the police asked him about whether or not he had had prior contact with this individual to see what their relationship would have been and what was going through Jason's mind at the time of the shooting. Let me tell you what went on 2 months before this. He had had contact with Kyle, and Jason's recollection was he said that meaning Jason, in his first contact with Kyle took place. I don't know what to tell you. I don't know who you are. And then Jason would say, and he kept just kind of giving me a hard time about it. So I just walked in the house. He must have gone inside. Then, like I said, I didn't see him. After a while, I was in the driveway and he walked by. But he did have another person with him, a friend with him or something. He began, called me a rat, told me he was going to fucking kill me, kill my family. And then his friend said, come on, let's go. And he moved him along. That was a contact that was given to Officer Garston in this statement. And there's reference to it on more than one occasion because the officer wants to know whether or not, obviously, whether Jason did anything to get this guy angry at him. And he actually asked Jason what that interaction was all about and what it resulted in. And Jason's recollection was that he was enraged, that meaning Kyle. He seemed as though he was paranoid, claiming that Jason had done something that he had not done. He described him as mentally ill. In fact, I think he described him as psychotic. It was gratuitous. He did nothing to take on that kind of anger from Violette. And he went into some detail with the officer because that was the foundation of how he knew Kyle Violette. And it was surprisingly similar to what took place on April 4th, 2024, when gratuitously, in Jason's mind anyhow, he was approached again by the same individual acting out of control and enraged and threatening to kill him and his family. Almost the same type of pattern. Additionally, I can tell you that this actually scared him and his daughter to the point, and this goes into the statement as well, that when his daughter would come home from work at night, she would call from her car, Jason, so that he could go down and bring her into the house, escort her into the house. So there's some history between the two. It's not a wonderful history, and it's not, a lengthy history, but it's a significant history. It's a history that concerned him about the specific alleged victim in this case, and was concerning because his life and the life of his family was threatened before by the same individual that he had contact with on April 4th in the evening. So, again, it's a transcript that was developed by police inquiry on the subject of what was going through Jason Levesque's mind when he came upon KYAL Violette. Part of what was going through his mind was being placed in the same situation, a similar situation that he was placed in 2 months before, and that it was an enraged individual that had no basis for coming up with the statements that he came up. 2 months before, Jason had done nothing to cause that kind of a reaction. And on April 4th in the evening, he had done nothing to cause a death threat on the part of KYAL Violette. So it is part and parcel of a police interrogation while he was being questioned by the police at the Rochester Police Department. It certainly does touch on very important issues with regard to this case. And the state's talking about me having to file a 404B motion or a motion to limit. If they wanted to cut out and redact a defendant's statement, one would have thought they would have brought that to the attention of the court prior to right before placing the officer on the stand that actually questioned Jason about the very subject they're trying to eliminate. It's relevant. It goes through his state of mind. It goes through the self-defense instruction. So again, I don't know how they're going to keep this out. I mean, it's part and parcel of the criminality of the statement.
Well, is the argument, I guess I'm confused a bit because there's sort of different levels of argument that have to be teased out. First is the hearsay issue, right?
No, it's an admission by
but that's not,
Mr. Levesque is giving a statement to the police. It's admissible. They're putting it in.
well, they're putting in the admissions from that statement.
Well, they're putting it.
Are you arguing that the whole thing has to come in under the doctrine of complete? The state's not required necessarily to put in
Well, I think if they
the
put
self-serving, the statements that they believe are self-serving or that don't fall under the exception to hearsay, do they? Because they're not.
I think in the
admission
doctrine of completeness, Your Honor, that yes, the statement does go in. And if you want the complete picture for the jury, it goes in. Now, if they want to carve out some crazy irrelevant thing, that's fine. This isn't crazy irrelevant. This was the subject matter brought up by the police on the night of the shooting, right? The contact that he had with the alleged victim in the past. This is hardly some remote, strange subject matter. It's what anybody would be asking anyone in that kind of situation. Did you know this guy? How did you know him? Why would you have been afraid of him? Here's why.
So 801's exclusion says, hearsay doesn't apply to a statement that is offered against an opposing party and was made by that party.
Right.
Hold on 1 second. Well, what's your position on that, State? What's your position on the hearsay issue and what portions of this statement do you believe are excluded from the hearsay rule under 801?
Yeah, if you could bear with me and just go one step further back to this defendant's statement that hey, look, we don't need to file the 404B motion because the state's introducing aspects of this transcript. Let me be clear, we're not the proponent of the prior bad acts some 2 months before this incident. So that analysis, I think, is entirely misplaced. In terms of the completeness doctrine, then, there is no bearing on the description the defendant provides concerning the relevant material acts here, which is the defendant's statements and his movements during the course of this particular night on the 4th, and the events from 2 months earlier. This just creates this classic sideshow of a trial within a trial. And on that point, Judge, had the defense litigated this issue, we would have had the opportunity to, for example, bring Kira in here to assess and weigh the actual scope of it between 2 witnesses. I just heard him say that Kira would make phone calls to get picked up from the car when she came home from the, in the driveway or something. And I read her statement, and there is no reference to that happening. She says, I don't have any personal knowledge of it, but my dad claims that there was an incident some time ago, and he'd come out and get me. He came out and get me. It's referred to in the singular. And she revisits that later in her interview and says, can you talk about any, fear for this guy? No, I wasn't in fear because my dad was there. We've gone through that. I've had a few times I've seen him and he gives me a weird vibe. That's hardly a lunatic next door that they're trying to make this claim. And the fact that, like, out of random, when my dad had to come get me out of my car, that was, there was nothing to provoke it. And also, I just don't trust people. And so the gap between Kira's assessment of it and the defendant's claims just now are significant as a point to merit a 404B hearing. But that aside, the completeness analysis would require the state to introduce a statement or a portion of the statement that was somehow unfair and would be recast by the excluded, redacted section. I can tell you, I suppose we can take it as it comes, but I certainly don't have any plan to, broadly declare you have no prior history with this individual. Oh, that's not quite accurate according to his statement, but I'm not going there.
So let me clarify. So this, how long, the transcript's like 100 and something pages, you said, right?
Yes, 156 pages.
And how many pages of the 156 does the state intend to put in as evidence?
Quite a few.
Sorry?
Quite a few.
And what do those sections that you're putting in relate to?
So they relate to the defendant's initial description of the events that are frankly not in dispute. Confirming that he was able to speak accurately, willing to speak accurately about preliminary innocuous events. Then it goes into the area of his claims about why he drew the firearm and the effect of brandishing it. He makes essentially 2 sections of claims. The initial section is before Garston has seen any video and before the defendant has consented to any video. He doesn't consent till about page 66 of the transcript. And prior to that, he's committed to this. I pulled out the firearm. What was the Kyle's reaction? He became enraged and charged me. That's demonstrably false and at odds with the video. He charged me, and I had no choice. I think he was coming at me to attack me. He was coming at me to take the gun. I could tell by, the look in his eye. And so what did you do? I fired. What happened then? And by the way, Garston hadn't seen the video. He didn't seem fazed by it. He didn't flinch. He continued towards me, attacking me. All of that is coming in to show that the defendant was creating, manufacturing a self-defense claim until the jig is up. Then we've heard a lot about, he consented to video, but not yet. And he goes on to say, by the way, that, well, why did you fire the next 5 rounds? Oh, I fired those because he was continuing to come at me. Did he go to the ground after the first shot? No, he doesn't seem to be affected by it. He got more angry. And so, well, did you move towards him? No, I stood still and he was coming at me. And I fired 5 more rounds just to stop him. And did these hit him? Yeah, I think they hit him because he walked away holding his abdomen.
Okay. But I'm just trying to get clear. Thank you. But I'm just trying to get a sense of the section you're putting in.
Yep.
Is it all sort of one continuous part of this interview, say like 40 pages of it all continuous, or are you selectively cutting out little bits? Are you seeking to put in a contiguous or continuous section of the entire video?
So the short answer is no, but it's not to play sharp with the facts. It's, you know, the detective, like most, are trained in the read analysis, as you may know. That sometimes includes looping. In other words, they will have a defendant make a statement. It's kind of open. Defendant puts it out there. They'll go on to other areas. Then they'll loop back and, hey, I want to revisit this issue of actually brandishing the firearm. And so I am following along the fundamental narrative of brandishing the firearm, the first shot, and the second rounds of shots of 5. Those are repeatedly, you know, restated, but again, have no bearing on, you know, at the time, I'm thinking about 2 months ago.
And is that part of the interview, the part about the 2 months ago incident,
That's embedded.
Is that an entirely separate part of the interview, or is it all sort of embedded in part of the interview?
I can't quite say that. So at the beginning of the interview, when he, for instance, talks about, you know, I was out plowing, came home, I did 1 swipe, I was changing. For whatever reason, the Garson asked, well, how do you know the guy? Oh, you know, I don't really know him. I think he's my neighbor. But 2 months ago, he was walking by and said, you're a rat. I'm going to kill you and your family is the claim. We haven't vetted that through any process, but that's the type of interspersement, but it doesn't have anything to do with. And so why did you brandish the firearm? Because he was coming at me, not because I have some historical reference or fear to him. Those are completely divorced in the transcript and in the conversation. You know, one does not modify the other.
Because as I look at this issue in the first instance, I'm trying to grapple with the completeness question, right?
Yeah.
Whether it's fundamentally unfair to the defendant to pick and choose sections, and whether it would be misleading to the jury and unfair to the defendant to sort of carve out little bits of the narrative if they're part of his narrative. I understand the issue of that prior statements of the defendant don't get to come in through the defendant because they're hearsay. The state can put them in because they're admissions. But there's a question of fairness under the completeness doctrine, which
agree.
is separate from the 404B analysis, which is a whole separate issue.
Yeah, I agree. You know, opponent of this could create misleading impressions, and you know, if I'm having a really bad day, I suppose I could do that, but it's certainly not. I'm aware of the issue. I can tell you that the transcript standing alone doesn't suggest anything close to an innate unfairness or completeness doctrine. It's not baked into the narrative of what happened that night. These are background questions that the detective asked concerning, as you would expect, you know, what's your history? But that didn't have anything to do with, was he coming forward or not? Did he stay on his feet after he took a shot to his head? Did he, where was he when you came over and unloaded the next 5 shots at him? Oh, he was coming at me. Right. Those aren't modified by a reference to some prior comment, even threat that the defendant, that the victim may have made.
All right. Attorney Sisti?
Yeah, I think we all better take a breath and, you know, recent case law here, like State versus Warren, 1999, that had its birth right in the very courtroom and was reversed because of the totality of the statement was was not introduced at the time of trial.
Yeah.
In a manslaughter case, stabbing case. I think, quite frankly, I'm sitting here going, why are we editorializing what's going to be said? Why don't we just plug the statement in, play it for the jury?
Well, it's very difficult for me to issue a ruling on this without seeing it. I really think it would be helpful if I could see the unredacted and the redacted and sort of, do you have a redacted one that you were prepared to?
I didn't black out anything, redact. Simply my outline was, and my manner of examination of the witness was going to be. Did you ask him about brandishing the firearm? Yes. I'm going to turn your attention to page 33, line 12, and can you share your question? Did you brandish the firearm? Why? And then have him provide the defendant's answers.
So you're not putting it in the sense you're not. Oh, I thought you were actually putting in the transcript as an exhibit.
Nope.
No. You're just gonna be asking him questions about what the defendant said during his interview and
That's right.
leaving out and focusing on the parts that you think.
That's correct. My decision about whether or not the transcript or portions of the transcripts come in was a function of the totality of this experience, that is direct and cross. If redirect, it requires, in my view, an actual transcript because things get messy. I may move to introduce portions of it, but in the first instance, I had not redacted, not knowing the scope of this.
All right, because I'll say I misunderstood then, because the way it was framed was that there was a redacted version of the interview that was going in, which now I'm hearing that's not what's happening. So the question is, you're gonna ask him questions about what the defendant said.
My reference was redacted by omission. We're just not going there.
He's going to talk about things that he said. You presumably at that point are going to then on cross want to ask the officer about other things that were said, and those are going to be subject to an objection at that point, and we're going to have to figure that out at that point. But I suppose we may want to talk about it now.
Yeah, we might as well talk about it now. I guess I'm going to say, let's play the whole thing. What are we doing? I mean, you want an accurate representation of what Jason was like on that night. You want to see what he was like on that night. You want to hear him speak. It's not what Attorney Arthur Isay said, or how he said it, or what he looked like. It's for the jury to make those determinations. What was going on with regard to him after 40 hours of no sleep, by the way, and being interrogated at the Rochester Police Department. Now, the doctrine of verbal completeness, if he's just cherry picking, all right, it's the same issue. We might as well get that out there now. And there's actual case law that speaks to it. It goes way back to civil stuff. In the beginning of the 1980s, in an opinion, I think it was from Justice Souter, Annington versus Hubbard or something like that. But it's really emphasized in State of New Hampshire versus Warren, 1999. I mean, this is you can't just cherry pick, especially in situations like this where there's a police directed interrogation. I mean,
you can't cherry pick, but we adhere to the rules of evidence, and that's what I'm trying to do. We don't simply say, the entire truth, set it free.
Right.
We're constrained by rules of evidence, and two, there's nothing about recent case law that recasts the completeness doctrine as something broader than this basic principle. Is it unfair by presenting one aspect of a statement that should be modified by a more complete version of that statement? And my position is I'm aware of that principle, and none of this invokes it.
And I think it's going to depend on the particulars of any particular statement and the part of it, how close in time this other provision that you want to bring up is to things that you've brought up, and whether it's sort of intertwined and embedded in those conversations. And that's going to require looking at the specific information that defense wants to elicit from the witness and how it fits into the testimony that you elicited. Would you agree? I mean,
Yeah, I understand. I think that's an accurate statement of what we live with in terms of a completeness doctrine. Anytime there's a broad statement that gets granulated with inadmissible statements, and this is just an inadmissible statement under Newell, and as a starting point, and now, am I going to elicit something that would be unfair without providing the statement concerning the prior event?
Well, his specific information about prior threats by the same individual is admissible, all right, in the self-defense claim. What's in his head about that individual is part and parcel of a self-defense claim.
Well, and
In other words,
but it may be admissible from your client talking about it, but that doesn't make it admissible in a prior statement, which is hearsay.
which is not hearsay. I'm stating it's not. It's coming in.
It is from you. You can't put it
It's
in.
not coming in from me. They're starting this thing, okay? But they can't just pick and choose, and that's what.
Well, the
Warren
picking
said.
and choosing, that's the completeness doctrine. Picking and choosing is a completeness doctrine. That's separate and distinct from the hearsay issue, which is you can't put in your client's prior statements for the truth of the matter because they're hearsay. They have to come from him if he wants to testify.
Understood.
But you don't get to put them in yourself.
Yes.
But if completeness requires them, then completeness requires them.
That's what I'm saying. You're asking whether this is some kind of a segregated part of the interrogation. No, it's not.
Well,
It comes up more than once. And, you want to talk about cycling and all this other, techniques of interrogation. Well, it comes up more than once.
all right.
The police officer's interested in it. He wants to know why this happened that night, who this guy is, what their relationship was. And I'll tell you right now, it wasn't good. It wasn't extensive, but it was a similar or same threat to kill him and his family.
I think the only way I can effectively rule on this is I've got to look at it. At least take a few minutes to look through it. I also do want to go take a quick look at the Warren decisions and case law. I hate to do this because now it's 9:44. We've had the jury sitting for 45 minutes. This case is, anyway, I'm not going to editorialize it. Everyone's doing their best, I understand, and these things happen. Obviously, so want to give me the statement, please. I'm going to take a few minutes off the bench to look at it.
I have a statement. I don't mean to be presumptuous, but I also have an outline. This is without editorial comment, which could direct some support to page 23, unless you want to just do a clean read.
I think it should be a clean read. In fact, it should probably be marked as an exhibit.
Well, we'll see. I mean, through the testimony, I'm going to need to probably have this in front of me because when objections come up and questions come up about, well, I want to ask him about this. The only way I can be able to rule on that is to have some sense of the whole document, I think.
I want to make sure I give you a
Yeah, this is clean from what I can see. I don't see any other marks in the account.
Yeah, mine's here.
Obviously, if I saw marks in it, I would be worried. No marks in this. All right, let's take 5 or 10 minutes. Give me a chance to get my head wrapped around this. I apologize to the jury, even though they can't hear me. I'll be back. All right. and I was walking by the open door to the jury room. As I walked by the jury room, I made a sound of frustration as I walked by the door, which I can best reproduce. It was something like, as I walked by, and I happened to glance over. The jurors heard me make that noise, and I actually saw them laugh at the fact that as I walked by the jury room, I expressed a verbal sort of expression of some frustration, and they heard that and they laughed. I don't know what to make of that. I don't think it is any prejudice to either side. I can't imagine that they're going to infer from that anything in particular other than that the truth, which is I'm frustrated by the fact that, this is taking some delay to get this case moving, and that I was in my head thinking about these issues and trying to work through them. So I just raised that to your attention because it was a sort of brief quasi-interaction between me and the jury, which was totally unanticipated. I didn't know they were in that room. I didn't know the door was open when I walked by. Does either party want to say anything more about that or feel the need that we need to address that with the jurors? I don't think we do, but.
Well, I agree. I think that's probably the general consensus of everybody involved in this trial at this point. I don't think we need to blood here.
Attorney Sisti, do you have any concerns about that? And again, there was no words. I did not say any words. It was simply a sound that I made. Okay. Going forward, I'm going to make sure that that doesn't happen again. But anyway, all right. I've had the opportunity to review, particularly I reviewed State v. Warren, which is a case involving the completeness doctrine. And defense counsel is right that otherwise inadmissible evidence can be admitted under the completeness doctrine if it's necessary to prevent a party from gaining a misleading advantage. Under that doctrine, a party has a right to introduce the remainder of a writing, statement, correspondence, or conversation so far as it relates to the same subject matter and tends to explain or shed light on the meaning of the part that's already received. Right, so that's the standard. I mean, Warren was a much cleaner case in that it involved a statement in which the defendant had made certain admissions, but as part of his statement, he mentioned the fact that there was one particular sentence, I think, about a knife that the state was trying to keep out, and the court felt it was unfair to keep out that one statement about the knife as part of this narrative. Looking at Warren, I think the only way to proceed is for the state to put on its evidence, to have the witness testify, and then when the defense wants to ask questions about other parts of the statement, I'm going to have to make a case-by-case determination as to how close in time the other statement is to the statements that the state has already put in, how much it's intertwined with them, how close it is in terms of subject matter, and whether it would be basically unfair not to have that portion of the statement introduced to put the rest of it in context or for completeness purposes. I don't think I can make an advanced ruling without hearing how the testimony comes in. And I don't think Warren or any other case that I'm aware of requires that the entire statement be put in or that the video be played in its entirety. I'm not aware of any such cases, but I welcome it to you all, either of you is. So that's my position at this point. So I think we just have to proceed. Either side want to say anything further on that question?
As far as close in time, I mean, it's obvious it's close in time.
Well,
I mean, you read it.
I don't think close in time means the whole interview. I mean, the interview itself probably took
3.5 hours.
3.5 hours. Right. So I don't think you can say that the entire interview is all close enough in time. I think you have to look at the particular statement and how it is connected to other things that the state has introduced.
Yeah, it's like 2 pages away
For example, I note that the interview starts off on page 17 where Officer Garston asks him, so what's going on tonight? And he gives a long narrative answer that ends on page 20. And interspersed in that answer, there is some discussion about these prior incidents. I mean, and I think there is an argument to be made that that is part of that statement and is intertwined with it. But then immediately after that, there's a long 10-page discussion just about the prior incidents. I think there's an argument to be made that's not intertwined with any of his answers. So it's going to be a case-by-case or statement-by-statement analysis. I don't see any other way around it. Attorney Barth, were you going to say something?
Well, if we could, maybe we can, maybe we can't get a ruling then on if the witness, Garston, says he, gave an open-ended question, what's going on tonight? Does that, from the court's perspective, invite addition of the prior, reference to the prior incident?
I'm looking at page 23, where they're discussing the initial confrontation. And on 24, a page and a half later, they're talking about the October one. It's intertwined.
I disagree. I think 23, he's still talking about the prior incidents. He's talking about the prior incidents at that point. And that's the part of it. I will tell you, counsel, I think when I look at what is on pages 17, for example, on pages 17 through 20, where he asks him the open-ended question about what happens, and he's telling him about, he comes out, says he's going to kill me, kill my family, and I don't know who he is, and this isn't the first time this has happened. It strikes me that that is all intertwined as part of his answer. And if you elicited portions of that, I think it would be fair game for the defense on cross to ask him, well, didn't he also say during that answer that there had been prior incidents? I think it's all intertwined in that answer. Now, does that also mean he can then delve into all the details of every other time he's talked about that? Not necessarily. But in that instance where it is literally intertwined in that part of his answer about what happened that night, why he did what he did, and then he goes on to say, and this isn't the first time this has happened, he did it. I think reading State v. Warren, I think there's an argument to be made it would be unfair to carve out that one little bit of that answer. So I can tell you on that one, I think that is how I would rule on that one. Now, it's a long interview, and I can't tell you exactly how I'm going to rule on the rest of it, but that's my thinking. I don't know if that changes anything.
Can I have just a quick chat?
Sure. Yourselves? Sure. You want to take a recess?
Please.
Yes. All right, we'll take a recess.
took place.
And back at the station, did you in fact conduct an interview with Mr. Levesque?
I did.
I obviously want to spend some time on that, but I note that you had some other tasks which followed. Let's just go through those to address your investigative tasks associated with this case. Following the interview, looks like the next day, what did you do concerning this case?
So on the 5th, I reached out to the ATF to request a trace on the firearm to find out who the original purchaser was.
And were you able to follow that up with ATF assistance to actually conduct an interview of the genesis or origin of the firearm?
Yes.
Did you document that in your report?
Yes.
And then just to help things along here, my understanding is that on the 8th, you requested all the dispatch and 911 tapes.
I requested all the dispatch tapes. I'm not sure on the exact date, but it was a couple days after.
And what was your reason for doing that?
To identify any other additional potential witnesses that we haven't spoken to. Also, if there was any excited utterances, during the heat of the moment, someone might say something that they might not remember later on.
And did you, in fact, listen to all those correspondence, the dispatches, and memorialize that, take notes of it in your report?
Yes.
Did you follow up on any potential leads for witnesses in the surrounding area?
Yes, we spoke to a number of witnesses, myself and some of the other detectives, to try and identify any other potential witnesses.
In your view, did the people that you spoke to who had made 911 calls have anything materially to add beyond what you were able to obtain from the people who were on the scene and the video that you obtained?
There is no real additional information that was gathered from those interviews.
I'm reviewing your report as well. Did you have any responsibilities concerning physical evidence in this case?
Yes.
What did you do?
So I believe it was on the 11th. I took the clothing from the drying rack. So anytime we have clothing that might be wet, we put into a drying cabinet so that way it can dry. I took the clothing and repackaged it, so for long-term storage.
And was that essentially the extent of your involvement with physical evidence concerning, scene analysis or anything along those lines?
Yes, I didn't do much on the scene. I did photograph the clothing as well prior to packaging it, but that was extended.
Let's see, did you, how far out, by the way, were you continuing to interview witnesses who were associated with the 911 calls?
So we identified all the witnesses that we could. We also checked social media. Any person that may have made a post that they could be a potential witness on social media, we reached out to try and talk to them as well.
And did you document those interactions and any statements people may have made?
Yes.
Once again, concerning social media, those contacts, did you determine, in your view, whether there was anything material to add to what detectives obtained from the scene and video evidence?
No, it was more that they heard the shots or that they had seen the police response, but nothing material.
Sounds like the heart of the matter for your involvement in this case was interviewing Jason Levesque.
Yes.
Let's talk about that.
Okay.
Describe for us the process that you said you took him into custody down at at 43 Summer Street. Just walk us through what happens next.
So whenever we take someone, whether they're detained or arrested or in custody, we would conduct a search to make sure that there's no weapons, contraband, firearms. He got transported to the police station in the back of my cruiser. He would be driven into the Sally Port. From there, I walked him into the booking area and then transported him via elevator up to the interview room.
And where did you ultimately take him?
To the interview room upstairs.
And talk to me about that interview room. Can you describe it for me?
So it's a approximately 10 by 10, 12 by 12 room. There's a circle table in the room. There's 4 red hard plastic chairs.
And look, this is at something like 10:30 at night. Can you share with us, describe for us how Mr. Levesque, appears to you?
He was able to communicate. He had expressed that he had been working prior to that he had picked up his daughter from work, and that he was going home to finish up his snow removal for his own home.
So before we get into the narrative, his account of sequence of events and things he heard and saw and did, I want to talk a little bit more about his appearance. He said he mentioned that he was at work. Did he share with you for how long he had been working?
Yeah, since approximately 10 p.m. the night prior.
24 hours at this point.
Yes.
Did he indicate to you that he was fatigued, tired?
He indicated that he was tired from plowing. Yes.
And did you, in fact, try and address that in any way? Did you provide him with, for example?
Offered him coffee, gave him a moment to compose himself as well. And he indicated to me that he was able to proceed with the interview.
Let's be clear, the food you offered him was like a Slim Jim
Yes.
along those lines. Did you ask him whether he wanted more than that?
I asked about food. I can't remember if I asked more than that. We did offer him some candy as well. It's hard to get food in the PD at 10:30, 10 o'clock at night.
Did he at any point, make any statements about his physical sensations, how he was feeling to you?
Yeah, at one point he did indicate that he was either lightheaded or dizzy.
Pardon me?
Sorry, at one point he did indicate that he was either lightheaded or dizzy.
And how did you respond to that, if you recall?
I asked him if he wanted EMS to evaluate him.
And what did he say?
He declined.
Did you continue to question whether he felt comfortable or capable of making a statement?
Yes.
Now, was there a period of time where you were frankly setting up? That is, did you go right into the interview, or was there a delay between arriving at the station and actually beginning the interview itself?
There's a little bit of a delay. There's usually some rapport building before you start talking about the specific matter at hand. Also some arrangement of the room. And we also had to gather a Miranda form that we could go over with Mr. Levesque.
And during this kind of setup process, did you recall whether or not Mr. Levesque actually asked to lie down early on the floor?
Yes.
And did you accommodate that?
Yes, we did.
Describe what he did.
He laid down at one point. We let him rest on the table when he wanted to rest. We didn't prevent him in any way from taking breaks when he needed.
And after that process where he said, I'd like to lie down, did you revisit whether or not he felt comfortable or capable of having a conversation?
I asked him multiple times if he was willing to, if he was okay, and if he needed any sort of assistance, or if he's willing to participate. Yes.
And from your perspective as an investigator, how did he appear during question and answer?
Yeah, he was able to recall fine detail. He was able to articulate himself. He was able to recall memories as far as what happened.
Was he responsive to specific questions, for instance?
Yes.
So you oriented them to the topics that you were asking about?
Yes, and even before the interview, he's asked basic questions as far as his name, address, date of birth, phone number. He was able to recall those. No difficulty doing those as well.
Then I want to get into the substance of your conversation with Mr. Levesque.
Okay.
Did you ask him about the specific activities that preceded his contact with Kyle?
Yes.
Let's do this. Was this interview recorded?
It was.
And are you aware that there was a transcript generated of this recorded interview?
Yes.
Have you had an opportunity to review the transcript and the recorded interview?
I have.
Your Honor, I'd like to approach this witness. Well, I guess I can do this foundation. Do you recall each question and the specific words that Mr. Levesque used to respond to each question?
No.
Would using or referencing the transcript assist you in your memory and it being accurate concerning the words you used and the words Mr. Levesque used?
It would be, yes.
Your Honor, may I approach this witness?
You may.
Your Honor, my request is to leave a transcript with this witness to refer to from time to time rather than the back and forth.
I have no objection to that. My question is, does it make sense to have one copy of the transcript marked as an exhibit for ID purposes?
Well, first of all,
Or-
it should be marked certainly for ID. I mean, we would refer it all. So,
Well, I understand that. We've had that discussion, and I'll allow you to remake that argument if you need to at a later point. But at this point, where it's going to be used to refresh his recollection, as I understand it? Or,
If we could briefly approach.
sure.
Your Honor, with the court's permission, I'd like to mark this transcript. Private application.
And counsel, I just would like to remind you that I have been told that some folks are having a hard time hearing. So to the extent you can sit right up
Yes,
close to
sir.
that mic. I know you're sort of
Yes, sir.
soft-spoken by nature, it seems like. So if you can keep your voice up, that would be helpful.
Yes, Your Honor.
Thank you.
how is that been marked? You know,
I'm sorry, what was that? All right. So the transcript is now States Exhibit 29 for identification.
Yep, 29. Sir, can you just take a look at that and confirm? We were just talking about whether you'd seen a transcript of the video interview. Does that appear to be the transcript you were referring to?
Yes.
I just indicated, I want to ask questions about the details of this conversation with Mr. Levesque. On page 33, line 25, is that the area where your question is about line 18, 19? Can you just read that to the jury?
I asked, okay, and you said you were going to clear the driveway?
What was his response?
Yeah.
And what did you follow up with?
Okay, and what happened after that?
And can you then describe Mr. Levesque's description of events before contact with Kyle on lines 22, following over the next page?
So I made a couple of passes, moving the snow towards 39 Summer Street. Then I turned around and I made one pass to grab the rest of it off the sidewalk and push it towards 43 Summer Street. Then I was going to backtrack the driveway, so I backed up and I got out to lock the hubs. They're the old manual locking hubs. They're not electronic or anything, so I got out to do that, and that's when he came up to the driveway.
And what was your understanding of what he meant by backdragging the driveway?
Sure, it's when you drop the plow and then pull it back instead of pushing the snow.
And so did you get into even a conversation about where that snow is going to go?
We didn't discuss the backdragging of snow to my knowledge, no.
Was it your understanding based on this description that Mr. Levesque had not completed his task of plowing his own driveway?
No, the driveway was still in the process of being plowed, is my understanding.
And the next question, did you ask him when it is and where it is that he first sees Kyle? I believe it's on line 6 and 7.
Yes, so I asked him, okay, where's the first place you remember seeing him?
And can you share his response starting line 8?
Yes. When I heard him yelling, screaming, or making some kind of commotion. I honestly don't know what he was saying. I remember hearing a voice or something coming from that direction.
Let me just take a little side step here. At this point, had you received and reviewed the videos that were ultimately obtained from 43 and 41?
During the initial interview, no.
And so at this point, were you able to, for instance, compare this claim that he heard yelling and screaming from 43 with the actual audio video evidence?
I was not.
And then did you follow up to try and get a better sense of where it is he first saw Kyle in the following question, which I believe is at line 12?
Yes, so I asked him, okay, and when you say that direction, which, and he responded from 43 Summer Street.
And did you ask more specifically where at 43 Summer Street?
Yes, so I asked him, like the corner of the house, the garage, and he responded, the driveway.
And your response?
So I asked him, the driveway? Okay, so you look, I'm assuming you look over because you hear the noise.
And what's his answer?
Yeah, and there I saw him come from where I can finally see him coming out of the driveway. He was putting on his shirt. He was shirtless, so he was putting on his shirt.
And so his answer to you of when he sees Kyle for the first time, he's actually doing something. He's putting on that hoodie.
Correct.
And were you able to later view video and confirm that Kyle did in fact put on a shirt or a hoodie all the way back in his driveway at 43?
Yes.
And so now from here, did you get into questions about, his actual appearance? You said you've established that his first time he notices Kyle, he hears something over there, and he actually sees him coming out of the driveway. I want to turn your attention to page 35. Did you try and get an understanding of what Jason claimed he saw in terms of Kyle's actions? And so I'm going to direct your attention to 35, line 6.
Yes, so I asked him, okay, so he was putting on a hoodie at that point. Describe, I guess, he's yelling at you.
Okay. And just before that, by the way, was he able to, even from that distance, give any kind of detail about, the nature of the shirt that he was putting on? And this is line 1 at 35.
Yeah, I described it as either green or camo hoodie.
And so then we were just saying, after the hoodie, did you ask more specific questions about, say, distance and activity?
Yes.
Line 10, what do you ask?
How far away from the truck does he get at this point?
And what's his answer?
Oh, he's walking at a very fast rate towards the truck.
And did you ask him now about concerns for, say, weapons, or if he was brandishing anything?
Yes, so I asked him, okay, anything in his hands?
And what were his answers?
His initial answer was, I don't know.
And did you pursue that?
Yes.
Line 16, what did you ask him?
Okay, are you able to see his hands from where you're seated on the truck?
And what was his response?
Yes, I guess I could see his hands.
And did you follow that up at 22 and ask him whether he was armed or had anything in his hand?
Yes, so I asked him, okay, and you're not sure if you saw anything in his hands?
And what is his answer at 24, 25?
I don't believe I saw anything. He had his hands clenched in a fist,
And then on 36, does he continue to describe Kyle's hands?
Yeah, so I said, oh, like this, and demonstrated a fist rather. And he responded, yeah.
Did he also demonstrate a fist?
Yes.
And did you go on to continue to ask about the details of what, if anything, was in Kyle's hands?
Yes. So I said, all right. But at that point, his hands are in a fist. Did you see him holding anything?
And what was his response?
I did not see him holding anything. I don't think so.
Is it your, I don't know if technique is the right question, but where somebody you're interviewing makes a statement or series of questions, do you tend to kind of loop back towards it? Do you revisit the same questions at a later time in the interview?
Yes. For an interview, you might ask the same question multiple times in different manners.
Like?
One, to check consistency. Two, sometimes further on in the conversation, they might recall something that they did not recall at the time, but mostly to check consistency.
Page 98, line 12. Is that an example of you revisiting whether he had a weapon?
Yes.
And what was your question?
Had you seen him with any weapon or anything at any point during any of this exchange or in the past?
And his answer is 15, 16.
I don't know. I don't believe so. No, I don't believe so.
On that same page, and he's described earlier in this conversation where he's coming over to the truck at a very fast pace. It's got his fist clenched. Did you ask him here about his daughter at same page, line 9? Oh, excuse me, no, yeah.
Yeah, so on line 7, I asked, was he making any like movements towards your daughter at that point?
And what was his answer?
No, he threatened me again, was just threatening me and I'm going to kill you and your family.
Okay. Then let's get to that, the threat. It seems like you've asked multiple questions about the threat. I'm going to go back to 36, which is the first description of this. You've asked him details like what he's wearing, if he sees any weapons in his hands, and then at line 15, 16, it seems like you're now getting into the threat.
Yes.
Can you indicate this line of question?
Yes, so I asked him, sneakers, okay? So he's coming at you yelling. Can you make out anything he's saying at this point?
And how did Mr. Levesque respond at line 18?
Yeah, he said, if you put that fucking snow at the end of my fucking driveway, I'm going to fucking kill you and kill your fucking family.
And did you ask, kind of any certainty or how specific that was? Can you give us the follow-up from that?
Yes, I asked him, okay, and just to make sure that we're not paraphrasing, is that and he responded, yeah.
And can you go on? What term does he use to describe it?
He describes it verbatim.
Is that his word?
Yes.
And on line 37, too, does he continue to confirm that those are the terms?
Yes, he says exactly what he said.
Did, at any point, I mean, you revisited the question about the threat.
Yes.
At any point, did it change to be more specific, say, towards Kira or daughter or anything like that, other than beyond, first, if you move the snow, I'll kill you and your family.
Yeah.
Did it ever change?
From what I recall, it was the same conditional threat throughout.
And you described him, you asked about the process of coming over, what he could see, what he heard. Can you describe then what he claimed about the actual encounter itself, where that occurred, how close that happened? Page 40, line 10, 11.
So I asked him, okay, and if he and if he reached out and put his hand on your shoulder, was that close and he responded closer.
And what did you say?
So I asked him again, closer, and he responds, because was literally his nose was touching my face.
And does he reiterate what was said when they were literally nose to nose or face to face?
Yeah, he reiterates, if you put that fucking snow there, I'm going to fucking kill you.
Put that fucking snow there. Did Mr. Levesque ever indicate what snow is going where?
I don't recall as far as specifics. I'd have to refer to a specific page if you have a reference.
And did it ever deviate from if you put snow somewhere, then I'm going to kill you and your family?
No, to my knowledge, it was still all a conditional threat throughout.
So he described to you a face-to-face, a nose-to-nose encounter combined with a threat. Did he describe what happened after the nose-to-nose encounter? Where did Kyle go? What did he do?
Yes, so after they exchanged words, or that, rather that Kyle made the threat, that he started to walk away.
And then I want to direct your attention to page 45, line 12. Well, let's start at 10. Excuse me, that's Mr. Levesque's answer. Your question is at 7. Can you share your question?
Yeah, so I asked, all right, so he starts walking away, you said, and how far away did he get from you at that point?
What's his answer?
Well, my truck was parked. If this was my driveway right here, my truck's parked here, and he had made it to like the front of the house, and that's when he stopped and turned around and came back.
And did he describe on page 46 how he claimed, Mr. Violet, how Kyle appeared when he turned around and started coming back, 46 line 10?
Yes. He said he's still very agitated. He's got his fist. He's very animated in how he's yelling. And just, he's going to fucking kill me and my family for moving snow, I guess.
And he claims at this point, while Kyle is in front of 43, that he's yelling these things, correct?
Yes.
And at this point, did you yet have the audio from 43 and from across the street?
We did not have the video or the audio at that point, no.
And did he describe to you on page 48 what he did in response to Kyle walking back towards the house? This is 48 line 9.
Yes.
Well, can you just share your question on
Yeah.
line 8?
So I asked him what happened next, and Levesque responded, when he started coming back at me again, I didn't want to I went and drew my firearm and I pointed it at him.
What does he claim happened after he brandished, that is, to take out and pointed his weapon at Kyle?
That Kyle continued towards him.
Well, can we be more specific? Line 13, same page. How does he describe Kyle coming at him after Mr. Levesque drew the weapon?
Yeah. And at that point, that's when he came at me. He was coming back at me like he was ready to go.
And did you kind of follow up on that? Actually, why don't you share with us your next question on 16?
Okay. So I said, okay, so let's kind of dissect that a little bit. And he responded, yeah. And then I asked him, so as far as he was coming at you, ready to go, help me understand what you mean by that.
What did he say?
Like before, he kind of was, his hand was in a fist. Now he was coming at me like he was going to attack me.
And you responded to that?
I responded, okay.
And did he continue to speak of this?
Yes. And he said, or he was going to take the gun. I don't know what he was going to do, but he was coming at me. He was ready to go.
And this is his claim after he takes the gun out and points it at Kyle.
Correct.
And again, did you have the video to compare his words to the images captured on 4 different videos?
Not at that time.
Did you try and get even more detail on this notion of Kyle coming at Jason with his pointed weapon in terms of how he was able to infer that he was going to be attacked?
Yes, there would have been follow-up questions to that, yes.
For example, a follow-up question on line 3.
Yeah, so I asked him, okay, and what makes you think that? And he responded, I don't know how to describe that, but I'm sure if you saw somebody coming, you can tell if someone's coming at you, and they're going to attack you. But if they're coming for, they want to take something from you or hurt you or whatever.
And did you have, again, did you revisit, did you confirm whether or not Mr. Levesque actually had the firearm out and pointed when Kyle was supposed to be coming at him to attack him?
Yes.
It's that page, again, 49, I believe you asked a question at 14.
Yes. So I said, okay, was the gun out at that point when he was, and Levesque responds, yes. When he started coming back at me again, that's when I drew the gun.
And did you ask more details about how far away he got or how far away he was when the gun came out?
Yeah, so I asked, okay, how far away was he when the gun first came out? And Levesque responded, probably about 10 feet.
And you?
So I said, 10 feet? Okay, and did you see his hands at that point?
What was his answer?
Yes, they were clenched and I asked, they were still in fists? And he responds, fists, yeah, right.
And just to clarify, did you continue to really make clear that this is when he has the gun pointed? And your follow-up question, did you ask, well, where was anything about the gun?
Yeah, so I asked, to be perfectly clear, I was getting some more information. I asked him where the firearm was prior to this, where he drew the firearm from, if it was in a holster, where it was on his body.
And what did he say?
He said that, that he was in his waistband in a holster, yes.
Okay. And did you use the term, and again, this is at line 3, page 50, prior to this description, these claims about what Kyle was doing?
Yeah. So I asked, and where was the firearm prior to this?
And what was his answer?
And he responds, in my waist.
And, just getting back to asking about Kyle's hands, at any point at this point, this is not the nose to nose, but where Kyle turns, does he claim that Kyle had a weapon or anything in his hands that could cause lethal injury?
At no point did he indicate that he had a weapon on him, no.
And his claim was that Kyle didn't stop, but rather came at him.
Yeah, that he continued to advance on him, yes.
In fact, you get into a little bit more detail about this on page 53. You asked a question at line 2. Can you share that?
And then you pointed at him, and he responds, yep. And I asked, and what does he do when he sees that?
And what are you referring to, pointed at him?
The firearm.
Any question about that? Reviewing prior page. For instance, 52 and 118.
Yeah, so at 18, I said, so you pulled out the gun with the right hand, and when it comes out of the holster, where is it going from there? And he responds, in my hand like this, and he gestures with arms stretched out in front of him, imitating pointing the gun.
Got it. And so we were at the point where you're asking some follow-up about what Kyle does when he sees the firearm. Can you share Mr. Levesque's claim at line 6, page 53?
Yes. That's when I guess the best way to describe it, it looked like a rage, like that really infuriated, like he was angry. He was coming at me and he was going to hurt me and take the gun, whatever, maybe.
And did you have some questions about that claim?
Yes, so I said, okay, what makes you, like I need you to be as detailed and descriptive as you can. And he responds, I saw him come at me, like the look in his eye, like he was angry, like he was pretty much gave me a look like it's you or me.
And did he describe how quickly, after the firearm was produced and pointed at him, how quickly Kyle continued to approach him?
Yeah, so I asked him, And when he was, how was, I guess, his pace towards you? And he responded, he was coming at me right at, I think, at a pretty fast rate. So then I asked him, did that change at all from before the firearm was drawn? And he responds, yeah.
And what's your next question?
All right, so he walked, and Levesque responds, he quickened when I drew the firearm.
And your next question on 54.
So I asked again, okay, so he went towards you faster, and he responds, yes. And I finished my question. Once the firearm was drawn, okay, how was it prior to the gun being, I know it was slower, but are we talking like he was walking? And Levesque responds, no, he was walking, a fast walk.
All right. I'm going to ask again. You've advanced a number of pages in the transcript and sequence in terms of the narrative. At this point, when he's claiming not only did Kyle continue to walk at him after he produced the gun, but he actually increased his pace towards Mr. Levesque. Have an opportunity to review the actual video at this point.
At this point now.
You have an opportunity to review the actual video of how Kyle responded once the firearm was brandished or produced.
Sorry, can you repeat that?
Did you have an opportunity to view this moment when how Kyle responded in the video when Jason brandished or pointed the firearm?
No, as I had not had the video, access to the video at that point.
Does Mr. Levesque explain to you what happened as a result of Kyle continuing to advance towards him in a rage and rapidly closing the distance?
He does.
What does he claim?
And as soon as I saw that look in his eye, I knew I had to protect my family, and I pulled the trigger. So then I asked him, okay, do you remember how many times the trigger got pulled? And he responds, yeah, 6 times.
And what do you ask?
Okay, so you fully emptied the clip at that point? And he nods in affirmative. And then he says, so the first one that I first shot, it hit him. He turned around and he walked away. And he turned back and he came at me again.
I'm sorry, he said that after he fired the shot, he continued to come at him?
Yes. Sorry. So the first one that he shot, it hit him. He turned around to walk away, is what he said.
Okay, and then what happened? He's walking away?
So he's walking away, and he said that he turned back and to come at him again at that point.
All right. Do you continue to follow up on that claim on 55, line 2 and 3?
Yes. So I said, all right, so you said that he turned to walk away, and is that where you said after the first shot? And he responds, mm-hmm.
We had talked earlier about you looping back later to the same topic, same subject. Did you do that concerning this moment after the shot was fired?
Yes, later on I did,
So
yes.
I direct your attention then to page 105, line 17.
So what was that page reference, counsel?
I'm sorry. Just confirming his actions prior to the actual shot. This is 105, Your Honor.
Thank you.
Detective Garcia, I direct your attention to 105, line 15 to 16.
Yes, so Detective Flathers asked, what was his reaction to you pulling out the gun? And Mr. Levesque responded, that's when he got angry, like he got really angry or like more aggressive, or I don't know what word I'd ought to use, but you'd think he was not happy, like he wanted to come, he was going to get, hurt me or take the gun or something like that.
and then at 106.2, does he continue to make this claim? Or actually, is it Detective Flathers continue to ask questions?
Yeah, so Detective Flowers asked, so you're taking out the gun didn't make him stop where he was?
What is the claim?
Levesque responded, right.
You know, what I think I forgot to do is some basic housekeeping. You just mentioned Detective Flathers. Can you tell us when Detective Flathers came into this interview?
So he was in the first part of the interview, some of the last part of the interview, he had stepped out.
Okay. And can you just identify Detective Flathers for the record and for the jury?
Yeah, Detective Flathers is one of my coworkers. He works for the Rochester Police Department, and he has been working for the police department before I got hired on there, so it's at least over 10 years.
Your inquiry concerning the shooting itself. You talked about brandishing a firearm and his claims about his response to that. Page 55.
Okay.
17, you asked a question concerning the actual gunshot.
Yes. Okay, and he's coming towards you, so 5 feet or less, the first shot goes off. Do you know where roughly on his body, though, it hit?
What's his claim?
No.
In fact, you continue to press that.
Yes, so I said, okay, do you know if it actually physically hit him, the first shot? And he responds, I think so.
And is this an area that you revisited later in your interview?
Yes.
I'm going to direct your attention to page 111, 1 through 2. What was your question?
Was it your intention to stop him, to kill him, something else, like
What's his claim?
just stop him?
And do you follow up on that?
Yes. So I asked to stop him. Okay. Did any of that change during the next series of shots that went off?
How did he answer that?
No, the first one didn't. I think it affected him he heard the shot, but it didn't stop him.
I'm sorry. So his claim at this point for how Kyle reacted after being shot in the head was it didn't seem to affect him.
He indicated that the first shot didn't stop him, yes.
He didn't describe him going down to the ground.
No.
And this was in response to your question about what was your intent, to stop him or kill him?
Yes.
Page 54, this appears to be also in the same area of inquiry. I'm going to direct your attention to 54 lines 21 through 23.
So Levesque says, so the first one that I first shot, it hit him. He turned around to walk away, and he turned back and he came at me again.
Okay, we had just visited that, and so now he's indicating that he had struck Kyle with the first shot, but actually describes him walking away and then turning around and coming back at him. Am I understanding that correctly?
That's what he indicated at that time, yes.
Does he describe him going down on the ground and crawling away?
Not during the initial interview, no.
You indicated that you had asked him about the distance that he shot him at the first shot. You recall how far away he claimed it was? This is 55, 9 and 10.
Yes. So Levesque says, the first shot was a very pretty close distance. I would say maybe 5 feet or less.
And do you remember whether Mr. Levesque claimed that he actually closed the distance or whether he stayed put and it was Kyle who closed the distance to supposedly 5 feet. or less.
Yes, so I asked him, and you were still standing at this point. You hadn't like gotten back down or anything, I'm assuming, right? You're still on your feet? And he responds, yeah. And I asked, okay, and he's coming towards you, so 5 feet or less, the first shot goes off. Do you know where roughly on his body that would hit? And he responds, no.
At 55 line 21, you asked, do you know if it actually physically hit him, that first shot? Do you recall his response at 23?
He says, I think so.
And did you follow up on that?
Yes, I asked him what makes him think that.
And how does he describe his basis for thinking, he might have hit him at 25?
So he responds from the way he moved, like you could tell something hit him. Maybe it didn't, maybe it was just the.
Can you back up to line 1?
Yes.
And reread that on page 56? Did we give you a bad copy?
Yeah, it looks like some of it was cut off.
I'm going to approach this witness, Your Honor.
Please.
How pervasive is that? That's pretty bad. I'm going to show you is a better copy and ask Your Honor, and for the record, this is 56 continuing on to line 1.
Yes. So you could tell maybe something hit him. He flinched, or maybe it didn't. Maybe it was just the noise. Like he reacted to it, I guess would be the best way to describe it.
Did you say flinch?
Flinched, yes.
And that's according to Mr. Levesque.
Yes.
And he added, maybe it was just the noise that he was responding to.
Yes, he said maybe it was just the noise, like he reacted to it.
So from his claim of being 5 feet away and discharging the firearm, he doesn't indicate, I shot him in the side of the head and he fell to the ground.
That's not what he indicated at that time, no.
He flinched as though he might be reacting to noise.
Yes.
And did you follow up on that, 56, line 5 and 6?
Yes, I asked, did you hear him make any sounds or say anything? And he responds, I don't know if I heard him say anything. I mean, the gunshot did just go off kind of loud, but I did see him react and either it was the noise or something had hit him or it surprised him, but he was definitely a reaction from it.
Okay, so he doesn't change that initial claim that it was maybe he was hit. He actually commits to it. It provides a little bit more detail. That maybe Kyle was surprised by the sound of the gun.
Yes.
And did you follow up and ask, more about Kyle's reaction to this gunshot going off?
Yes, I asked, okay, does he stay on his feet? And Levesque responds, yeah.
Okay. This is in reference to the first gunshot going off. And he's described his reaction to it as maybe being surprised, maybe surprised by the noise. But you ask physically, what does Kyle do? And his claim was Kyle stayed on his feet after being shot?
That's what he indicated, yes.
And does he describe what Kyle did after staying on his feet somehow?
Yes, so I said when the first shot goes off and you said he turned, which way did he turn? And Levesque asked, so you mean like counterclockwise or clockwise? And I clarified saying, like, which direction was he turning? So Levesque says, so then he turned, he was still heading for me. He started going back towards his house.
And did you get more specific? So initially, he claims he's actually continuing to head towards Jason Levesque.
Yes,
But then he turns to his house. Did you ask for more details on that?
I did.
What did he say?
So I said, and how many steps did he make before he turned around a second time? He responds, one, a couple. So I said, so he went a couple of steps, and then did he say anything or do anything, or just kind of turned his body around? And he responds, he turned his body back around.
And he turned his body back around. His claim is that he turned his body back around towards towards Jason.
Towards Mr. Levesque, yes.
And now let's focus in on what he claims happened next. This is 57, line 3.
Yeah. So Mr. Levesque says that he turned his body back around. So I ask, all right, and then what happens? And Mr. Levesque responds, and then I unloaded the gun.
So this claim is that Kyle, after being shot, turns back towards Jason on his feet before the next rounds of ammunition, the next 5 rounds go up.
Correct.
Didn't say anything about him being on the ground?
And not at that time, no.
And did he actually make any claims about the distance that Kyle closed on Jason before he fired 5 more rounds? This is a continuation.
Yes. So I say, and how far away was he when those next 5 shots went off? And Mr. Levesque responds, a couple of feet. So I asked to clarify. And just to be clear, I want to make sure, what's a couple of feet? Mr. Levesque says, I would say 3 feet, 5 feet. And then I ask, all right, so he was about 3 or 5 feet away? And Mr. Levesque responds, yeah.
Okay. From that distance, standing in front of him, did you ask anything about the injuries or the shots connecting in any way?
Yeah, so I asked, and do you know if any of those shots connected? And he responds, I'm guessing, while nodding his head in affirmative, just due to the fact that he ended up like how he was holding himself, and he started walking back towards his house, like holding him like he had been hit.
That after taking the 5 additional rounds, Jason Levesque describes him holding himself and walking back to his home.
Correct.
Do you ask any follow-up for detail on that claim?
Yes, so I said, okay, where was he holding himself? And Mr. Levesque responds, I believe on his abdomen. So I ask him his abdomen, and Mr. Levesque responds, yeah.
Is this the kind of detail you were referring to at the outset of our conversation when you said Mr. Levesque seemed responsive to your questions?
Yes, he was able to answer questions asked in multiple different manners and provide fine detail as well.
Did he ever say, look, I don't even know what you're talking about anymore about firing the gun or where he was positioned? Did he ever invoke to you, this basic confusion, I'm too tired?
Later on in the interview, when he did ask to put his, to think for a minute, to have a moment where he put his head down, but then he was able to clarify. But at that point in the interview, no.
Was that after you shared the fact that investigators were looking at video?
That we indicated that we had finished the initial investigation, that we had spoken witnesses, that we had a video, yes. And in fact, during that time too, we asked basically for me to reiterate what he had previously had said at that point.
Just to continue on the detail associated with him holding his abdomen after being shot 5 additional times. Did you ask some follow-up questions for detail? Page 58, for instance, lines 4 to 5.
Yes, I asked him if he saw any blood or anything at that point, and he responded that he didn't.
Couple of follow-up questions. Said that Mr. Levesque consented to the sharing video, giving you access. I just want to clarify this concept of consent. If you could share with us, really what are the two main avenues available to law enforcement to obtain physical evidence?
Sure. Typically, whenever law enforcement is trying to get evidence, as the counsel had mentioned, there's typically two manners. The first one being consent. So someone can voluntarily provide consent as long as they're the owner of the property or have some sort of constructive ownership of the property. The other one being a search warrant. So we basically ask for a permission slip from the judge granting us permission to either search or seize some property.
And so consent, is this something you're familiar with utilizing, not in this case, and more broadly speaking, as a tool to enhance investigations?
Yes, we get consent all the time in cases from both victims, suspects, witnesses, from a good amount of people throughout the course of investigations.
Let's focus on suspects. What's your experience in suspects of crimes granting you consent that subsequently leads to damning or incriminating evidence? Do you have a conversation with the defendant, Mr. Levesque, about what he did after the shots were fired?
Yes.
And I'm going to direct your attention to page 61. And I think your question is line 4.
So I asked him, what did you do at that point? And he responds, I got back in the truck.
Did you follow up for more detail?
Yes. And Mr. Levesque goes, and I took the clip out of the gun and put the gun up on the dashboard and sat there and thought what would be the best thing to do or safest thing to do before any of you guys got there. I knew you were coming, and I pulled the truck into the driveway so I was out of the road. And I tried the phone to call 911, but then I heard the sirens coming, so you guys were already on your way.
And did you ask him about any conversations he may have had with his daughter?
Yes, so I said, okay, did you talk to your daughter at all within the truck? And Mr. Levesque responded in the affirmative. And then I further clarified, what was the conversation you had with her? And Mr. Levesque said, I said, Kira, I'm sorry. I said, I'm sorry, that shouldn't have happened in front of you. And she said, it's okay, you're protecting me, I know.
And did he make any admissions about asking Kira whether he should run or not?
Did he make?
Yeah.
He did not say that at that time, no.
Did he provide any details about a conversation where Kira was giving him advice not to run?
No, he didn't indicate that, no, not during our interview.
We had talked a little bit about how he appeared and his sharing that he was quite fatigued when he first came down to the police station. Did you follow up, or did he make any statements concerning how that may have impacted his judgment back at the scene? And I want to direct your attention, I guess, first to page 75.
So Flathers asked, yeah, worked 24 hours, and Levesque responded, yeah, and I was up all day the night, and I was up all day the day before because they didn't call me till 6 o'clock to say that I was going in at 10.
And on line 13, did he indicate how that may have factored in at all?
So he responds, yep, maybe that's why I was laying down. Maybe it's just I've been overwhelmed. I don't know. I'm sure that it probably has something to do with my, probably making a bad decision and not thinking clearly.
A bad decision and not thinking clearly?
That's what he said, yes.
And does he make any references to that again? I'm going to direct your attention to page 150, line 12.
So at that point in the interview, Mr. Levesque says, if I wouldn't have been up that long, it probably would have had a different outcome. I don't know. Who knows?
If he hadn't been tired, he wouldn't have shot Kyle?
That's what he was expressing, how I took it at least.
As you know, attorneys assist you like this and follow.
Thank you. Good morning.
Good morning.
We go through some preliminary stuff with you too, because the jury heard that this entire interaction with Jason was video recorded, correct?
So while Jason was in the room, yes, it would be recorded on my body cam, correct?
Right, and that means that you have a video recording of the interaction at the Rochester Police Department that would be full and complete, correct?
Of when I was interacting with Jason, correct?
Right, and that video recording would also show the jury what Jason looked like that night, right?
It would.
And that video recording would more perfectly explain what he looked like rather than your answer to some questions, right?
Video would show more accurately someone's description than my words, but I could also articulate as far as what he was wearing or what he looked like because I was there.
Yeah, what he was wearing and what he looked like. How about what his face looked like and how he looked as far as being alert and physically fit? How about that?
If you had specific questions about that, I could try and recall as far as what your questions were, yes.
But we actually have video of how he looked, right?
Correct.
We actually have video of him and how he was affected by being up for over 40 hours, correct?
There's video, yes.
And there's video of him literally laying down, trying to rest, right?
There's video, yes, of him resting.
There's video of him telling you that he's feeling hot, right?
Correct.
There's video of him being helped by you so he could sit down, right?
When we're first walking into the interview room, yes, he was escorted into the room, yes.
Right? And you didn't want him to stumble or fall, right?
Correct. I do not want him to stumble or fall.
Right. And he's complaining about being hot, right?
At one point, he was complaining about being hot, yes.
About being exhausted,
Yes,
about being overwhelmed.
yes.
And in fact, you're concerned to the point, before we're getting into any of this question and answer, about whether EMS should be called, right?
Yeah, so obviously, whenever we have someone in custody, there's a concern about liability. So if there's any concern about someone makes an expression that they're, tired or shaky, we'll at least offer up EMS. Whether or not they take it, as long as they're competent, they're able to make that decision for themselves.
And he did express that he was tired, right?
Correct.
That he was shaky, right?
Yes,
That he was dizzy,
yes.
that he needed to lay down,
He has to lay down, yes.
right? And he did say that he was confused at times.
Confused, I'd have to look at a specific reference if there was.
He may not have gotten things right. He told you that.
Later on in the interview, yes, he expressed that he may have not gotten things right the first time once he was confronted on some of the other information we had, yes.
You were very understanding on that video, weren't you, detective?
So yes, as part of the interview process, we are trained basically that you get more information by being able to talk to people. If you're coming at someone a little bit harder, you're less likely to get information.
No,
Yes.
that's very understandable, but it's also understandable that he was going through some trauma at the time too.
Trauma?
You suggested he was going through trauma, that it was a traumatic experience.
Sure, of course, it would be a traumatic event for anybody for a gunshot to go off and shoot somebody.
Right. All right, so let's go through this a little bit. We've got a video that would more clearly and specifically express his mental state, right?
The video would be able to show basically how he was that day, yes.
His physical and mental situation at the time of the interview, right?
It would be able to show how he was that day, yes.
Yes, and it would be specific with regard to some of these questions that were asked by the prosecution, right?
It would be the same answers and responses from the transcript, but yes, it would be specific.
Well, there'd be a heck of a lot more questions than answers, wouldn't there?
Yes, it would be the entire interview, yes.
Yeah, the entire thing could be shown to the jury and
No
they would
objection
see
on
the
that.
whole thing.
No objection.
chat. This community is just the best. Love you all the different.
What, sorry?
Talking to him.
Talking to him, we didn't talk to him about specifics at that point. We were just bringing him into the room, get acclimated, build rapport at that point, yes.
Yeah, it was the first contact you had with him. He's already telling you that he's dizzy, right?
Yes, that's why I asked him if he would like EMS.
Right. And it was at that point in time you asked whether or not EMS should be called in, right?
I asked him if he would like EMS and he indicated no.
You told him that it's not unusual, right? That in fact, his body is reacting to stress.
Correct?
And let me just ask you as an aside, have you been involved in any officer shootings?
I've been on scene for one, but I wasn't directly involved with it, no.
I mean, let's go right to it. Have you ever discharged your firearm during the course of your service?
No, not at somebody, I'll say that. I've discharged it as part of training and as annual qualifications, those kind of things.
Right, but never during a situation where it was discharged and actually a round struck a human being.
No.
And even in your business, as trained police officers, you know for sure that your body would react in such a situation.
Correct.
And in fact, in your situation, the policy is there's a cooling off period before you make a statement.
I'd have to look at the policy. What do you mean by cooling off?
Objection sustained.
You haven't been involved in an officer-involved shooting, right?
I have not been directly involved in an officer-involved shooting, yes.
But you sympathize with Mr. Levesque that he would be experiencing stress, right?
Sympathize might not be the correct word. I'm doing an interview. I'm trying to build rapport, yes.
Well, you're trying to, doing a couple things. You're trying to, establish rapport, but you're also trying to make sure he's okay.
Yes.
Then you go over some medical stuff with him. You want to know whether or not he has any pre-existing medical condition?
I asked him at one point in the interview, yes, if he had any pre-existing medical conditions.
And you want to make sure he's sitting down so he doesn't fall, right?
For safety purposes as well, yes. I would like for him to sit down or lay down, not be on his feet.
And without him even asking, you offered him some water so he can relax, right?
For him, water, coffee, food, it's part of my training for interview and interrogation. As far as that, you typically, especially if someone had been out working all day, you want to make sure that they have access to bathrooms, access to food, that we're not treating them unfairly.
Yeah, we don't want to do that. And the other thing is that, again, as the prosecution said, the food that was offered was like pretty minimal, right?
It was a beef jerky stick and candy. That's all Flathers was able to come up with while I was with Jason, yes.
Let me ask you, do you know what he had eaten over the past 40 to 42 hours?
I don't know, no.
Isn't that something you generally ask to make sure that he's okay?
Again, I asked if I offered him food and water. As far as generally, I don't know if I've ever asked somebody when the last time you've eaten on an interview.
When's the last guy that you interviewed that had been up for over 40 hours?
I don't know if I've been in this unique circumstance before as far as interviewing someone that's been up.
Right. That's an extreme amount of time to be up without any sleep, isn't it?
You're asking someone that does shift work.
Yeah.
It's, as far as answering questions, I mean, I think everyone in the room has at one point in time stayed up all night and either had college courses or tests or final exams or kids. It was my understanding based
You knew he had worked all day, not only just stayed up all day, for 40 hours, but was working.
Yes, I've done, I've worked for a plowing company before. I know what kind of work it is, yes.
Right. And it can be very exhausting.
Probably less so for driving the truck, but yes, it is still exhausting.
Right. I mean, you don't know what else he was doing. Was he loading salt too that night?
He did indicate at some point that he handled salt, yes.
So he'd been in and out of the truck, right?
He would have had to handle the salt, yes.
You don't know if he was doing any hand shoveling either.
I don't believe that came up during the conversation.
Did you ask?
I don't recall.
At one point you said, if you feel like you need EMS, or if you just want water, Levesque says that would probably be good, right?
Is there a page in line that you're
Yeah, it's
referencing?
page 9, lines 3 through 6.
Yes, he responds, that would probably be good, yeah.
And then you take his handcuffs off so he can eat and drink, right?
Yes, I say, I'm going to have you stand up, take the cuffs off for you so you can eat and drink, still feel good, not like you're going to pass out, right?
And he says, no, I'm still wobbling.
Correct.
So at the point he sits down in the interrogation room and the cuffs come off, he's wobbling.
Is what he's saying, yes.
Yeah. I mean, he's expressing to you his physical condition.
Correct.
And you said, I'll have you sit down after just because I don't want you to fall.
Correct. And he says, I appreciate that.
Right. And you respond, yeah, no, it's traumatic, I'm sure. So you can have a seat. And if you want to take your hoodie off, right?
Correct.
If that makes you more comfortable if you're hot, right?
Yes.
And then he asked permission to take it off.
Correct.
And that's when you notice some blood on his hand.
Yes.
Do you ever figure out where that blood came from?
I asked him about it. He never clearly indicated where it came from. No.
Right. In fact, he was kind of mystified by it as well.
That's what he expressed. Yes.
So he doesn't even know where the blood, and it was on his, was it his left hand?
Correct.
He doesn't even know at that point in time, while he's sitting there with noticeable bleeding, where the blood would have even come from, right?
Yes. And to be clear, it was very minimal blood.
Right. You noticed it.
Yes.
Okay. He apparently didn't even notice it.
Correct.
And then you drew his attention to it. Right?
Correct.
And then he said, I don't know where it even came from. Basically.
To something to that effect. Yes.
Now, you want to give him some time to compose himself, right?
Correct.
And this is where you start building the rapport with him, right?
Yes.
But right out of the gate, direct your attention where it's nice to meet you and so forth, on the bottom of page 11.
Okay.
Where he says, my name is Jason,
Correct.
and you introduce yourself as Jake,
Yes.
and then basically he says, nice to meet you, Jake. Wish it was under different circumstances, right?
Correct.
I'm going to object to continue. It's just hearsay.
Can we approach?
Ladies and gentlemen, it is 12:03. And we are going to take our lunchtime break. The meeting will time, and so we can stop and take now lunch back to 1:03 or thereabouts, following lunch. Thank you, folks. All rise for church, please.
Okay. Thank you, Your Honor.
I just want to make clear, I wasn't ruling that the defendant doesn't have a right to introduce additional evidence to the prosecution. I just want to be important of the videotape. That things are always favorable. defense is going to do that. And there may be objections as to other issues with those portions of the videotape, like a hearsay objection, et cetera. We'll deal with those when they come. But I didn't want to foreclose that. So that's clear.
Very briefly.
Are we ready to proceed?
Yes.
Very good. Let's bring the jury out, please. Yes.
All rise, jury entering. Please be seated.
Good afternoon, ladies and gentlemen. We are ready to continue with the continuation of the cross-examination of this witness. Counsel, you may proceed.
Thank you very much, Your Honor, and thank you guys for being patient. Detective, let me just give a little introduction of what we're going to be doing here. We're going to play some of the video that was captured on your cam that evening, I believe, right?
Yes, sir.
And it starts at 10:17:09 p.m. and it's dated the 4th of April, and the location is 41/43 Summer Street. That's what we got going, and you're aware of what we're about to do.
Yes, sir.
Okay. Let me give a little introduction here. It's going to take about 25 minutes total recording. Some of it is dead time. You'll see some transport and detected. Some of it will be a muted body cam. Can you tell the jury why that happens? I'm going to try to sneak around here.
Sure. Sometimes we'll mute a body cam when we're by our personal spaces. People have family photos. There's other case information that necessarily we don't want.
It's been 12 months since acquittal, and so much has passed us by. Such a scattering with evidence, and some blatant flat-out lies. It's a special new prosector, and Hank Breeden is his name. He is a dirty Boston lawyer, and his arguments are lame. He's tried to squash all of our experts, as he has no case to claim. He should have won an Oscar medal to convince the court he's sane. He can lie without a conscience and keep that smirk upon his face. I bet he wears those silky undies, the ones with edging made of lace. And lawyers for the state is wading through 100 motions in a rush to seal my fate. So you can bring in Massachusetts, cause we all ain't got no quit. And we all know that the truth is my car is not the thing John hit. It's been 12 months since acquittal, and so much has passed us by, such as tampering with evidence and some blatant flat-out lies. Enter special new prosector, and Hank Breeden is his name. He is a dirty Boston lawyer, and his arguments are lame. He's trying to squash all of our experts, as he has no case to claim. He should have won an Oscar medal to convince the court he's sane. He can lie without a conscience and keep that smirk upon his face. I bet he wears those silky undies, the ones with etching made of lace. And Judge Beverly Kavanaugh is so biased for the state, is wading through 100 motions in a rush to seal my fate. So you can bring in Massachusetts, cause we all ain't got no quit. And we all know that the truth is my car is not the thing John hit. So you can't bring it in Massachusetts, cause we all ain't got no quit. And we all know that the truth is my car is not the thing John hit.
What do you think of that, eh? Bloody YouTube won't let me type bring it Massachusetts because you ain't got no quit. I bet he wears those silky undies with the edges made of lace. Yeah, I know. I'm a dickhead. I can't help myself. Do you get the Prosector and like special Prosector and Hank Breeden in there? That was on purpose. One of his motions, his one of his legal secretaries or whoever didn't proofread the motion, and the whole way through he was called Special Prosector Hank Breeden. Yeah. All right, I'm nearly ready. We've got 15 minutes before the motions hearing, so I'll just whack some face on, have some quick toast, and jump on for a second. Bye-bye.
One getting out.
But can you tell us generally what we're about to see? We're going to see a bit of the transport and the initial processing. Can you explain to the jury where we're going to go, what we're going to be in, etc.?
Sure. So as we kind of previously had talked about, this is going to show my initial response, showing up on the scene, and the actual transport of Jason back to the police station, and then transporting him up on the elevator to get back upstairs.
Okay. And can we assure the jury that we're going to be able to see some questioning, but they'll be able to see the condition that Jason was in on that evening when the questioning began?
You'll be able to see Jason before he was interviewed, yes.
Thank you. We could start that up. I'm not going to say a word during this. Afterwards, I may have some.
Okay, thanks, sir.
Step down.
Yes, sir.
Just for the record, clear, this is a full exhibit, correct?
That is correct.
Defendant, thank you.
So I'm just getting here. I don't know what's going on. So just you just be detained. Okay. Sorry, I can't hear. Oh, no worries. So we're looking to do. So we're gonna just head back to the station. We're trying to talk there just because it's kind of not the best environment for people yelling and stuff like that. And we'll kind of talk over there. Get out the weather too. It helps stay dry. 6 hours. The traffic with one detail to be monitored and to be approved. We're going to be up at 9 feet. No, you're fine. Any other reason, anything you need? Anything that changes? Not doing anything. What do you want? Yeah, it's stuff before it was a top I did construction and need some guys that are not behind the shoulder with the top trucks. So we'll head. Yeah, we took a couple of to you want to food right now? Okay, yeah, I can make sure that happens. Yeah, Mr. Paperwork for the color item on that board. So we don't need to go upstairs and there's chairs and tables. Okay, I just want to just want you to know what I'm saying. Okay. How much I need along the elevator, there's little chairs, tables, how much to sit down. And if you feel like you want us to check it out, something like that, more than welcome to ask me. I'll make sure that's what it is. So that's your body, we're going to do you have any medical conditions or anything? Are you getting walking percentages good for the trip? Oh, yes, we have that. Right here. And do sit over there. It's fine. I just relax some nerves a little bit. So this room is also the area I can see you for 1 second. I'll give you a couple more. Do you mind actually, you can also, this is a kitchen. Just go right downstairs. There's a kitchen and your countertop should be house. You get that just somewhere. This one. So then, okay. If you have any food, so he's going to get you some food, and then the other guy's getting some water. I know it's especially plowing all day. Long day. I'll take the cuts off. Yep. Guys, slim didn't work. You don't have any food allergies or anything like that. To do like commercial, residential kind of commercial. Okay. I'll let you know that. Do you work for them for outside of small, or is it just something? Or something like your day to day? What do you do for like your day? Oh, nice. Where do you do that? Okay. Right on 108 then. Always be a sound or. Okay, again, if you feel like you need EMS or you just want water, so I'm going to stand up, take the cuffs off. So the lid, nothing in the back. Light is back down. Just want you to fall. And one side. Sure. So you can sit, see, and you want to take your footing off. If anything changes, if you feel like you're too lightheaded, you know. So just gonna go over some paperwork and stuff. Yeah. Yeah, I know, I hear you. I just want to make sure that you're wearing rights and everything else too. You know, you sound pretty straight up honest. It's just kind of like something happened that wasn't planned, is what it seems like. So I just want to get, you know, the success out of stories. I just want to hear what your version of events, we'll kind of go from there. But I want to make sure that you're fully aware of what's going on before we're talking. So, make sure you get something for yourself for some stories. Sure to have one. And I don't know my first name, but it's just Jason J. Yeah, I mean, you want to have another research cycle everything. We're just going to check out there. You're good to just hang up here. Anything like that, turn the yard position. Help yourself to the beef jerky stick and butter. I don't know what that. You can only know the voice. You feel like you're gonna pass out? Do you want to mess? You know, okay. No, I just want to just talk to this guy while he's still on and talk to this. Right. I'm gonna take mine off, yeah. Yeah, camera up. Yeah, if you want to try and get that up too, I'll just be. I can't open that key anymore anyway. Next, if the room's video record, I can stop by. That's record on my phone too, or shake. Do you have that mount? I think mine's not the best for the other one. Yeah, just put it on the table. Do that. All right. Why don't you go do Flather's desk? I'll show you as far as getting the Peter split up to come on. Yeah. I don't. So then, okay. Yeah. Yeah, if you want to put your arm on. This is going first. JASON. We're not that. In a and we're going to talk about all this one. Basically, what that's all doing. All right. Yeah. And you said for the summer hall. Eyes are out. Right now.
Okay, we started that video at 4143 Summer Street at around 10:17 p.m. and it ends about a half hour later, approximately. Okay.
Okay.
And that's just the beginning of your contact with Jason on April 4th, 2024, right?
Yes, sir.
And that's what he looked at like at the very beginning of your contact.
Yes, sir.
And how many hours went by before you broke off with Jason?
When I last had contact with him or stopped because we took a number of breaks throughout.
Yeah, when was the end of the interrogation?
The whole body cam footage, I believe, is about 3 hours and 40-something minutes.
Okay, so it went on more than 3 hours from the time it cut off.
From my initial response time before the camera started rolling for today, all the way till the end of my contact with Jason, yes.
Can we safely assume that he wasn't given like an hour to sleep?
It wasn't a full hour, no.
In fact, basically you would leave the room at times and he would just lay down on the table.
Correct. He had also indicated that he would like to speak with me, so that was part of the other discussion that was going on as well.
Oh yeah, I mean, you guys went through an entire, give and take for quite a long time.
I'm not sure what you mean by that, sir.
Well, I mean, after we cut off on that video, you kind of basically started by building that rapport with him.
We had a conversation and then we started going into some of the details after reading him his Miranda rights.
Yeah, after you gave him his Miranda rights, right?
Correct.
Yes. And before you gave him his Miranda rights, you kind of did your introductions with him.
Yes.
And you made clear to him that you just wanted to hear his side of the story.
Something to that effect, yes.
Yeah, to the effect of, you knew that it went pretty quick that night and you just wanted his side of the story.
Correct.
Then you went over the Miranda rights with him. And then you basically said, the floor is yours. Tell me what the heck happened. Right?
Yes, I left it very open-ended to start so that way he could tell me what had gone on that night.
What he told you that went on that night was that he was plowing. And plowing in front of his home and the home of the, well, actually not even plowing in front of the home of the alleged victim.
So he said that he had done a couple passes, so he hadn't really started going too extensive with the plowing, but yes.
He never told you that he was plowing any snow onto the alleged victim's driveway.
He mentioned doing, I believe, if I'm correct, about 2 passes one way and then 1 pass the other. I'm not sure if he went into detail as far as where the snow ended up. If there's a certain line that you want me to reference, I can certainly look at that.
Yeah, but I mean, you actually looked at independent videos and you came to your own conclusion.
At one point later in the interview, I was able to watch some independent video, yes.
Right. And he only plowed up to that utility pole.
Correct.
Right. And that utility pole is on his side, his property.
I'm honestly not sure.
I'm not sure. It certainly isn't in the driveway of Mr. Violette.
The telephone pole won't be in a driveway, correct?
All right, so he was not plowing snow into the driveway of Mr. Violette, right?
I don't know that.
Well, you do know that. You looked at the videos, you had an opportunity to speak with him, I mean, photographs, I mean, the whole thing.
Yes, I've watched the video. I can't, personally, I'd have to rewatch it, the video to see if the snow ended up going into the driveway or not.
You recall no such thing happened.
From the vantage point of the camera, I couldn't tell you if the snow ended up in the driveway.
And the jury has access to the videos as well.
Okay.
All right, but you wanted to know what the contact was with this guy and what happened that night. He told you that he had just gotten home from picking up his daughter
Correct.
and that he was a plow guy. He was plowing and he had a black truck and he was doing cleanups all day.
Yes.
And he says he's starting to move snow and all of a sudden something's going on. He's going outside and he's locking up his house, right?
Yes.
Can you tell the jury how he explained that to you, what that was all about?
Yes. So he basically said he has to manually lock the hub, so he would have to get out of his vehicle to basically activate the 4-wheel drive in his vehicle.
Right, it was mechanical, it wasn't electronic, it was something he had to actually do manually.
Correct.
He explained that to you.
Yes.
And if you look at the video that the jury has had access to, that would be him bending over near the front of his truck.
That would be consistent with what he's explaining, yes.
And then he describes what happened. He says, all of a sudden, he came from his driveway, which is 43 Summer Street. Now, this would be meaning Kyle Violette.
That's my understanding, yes.
And he describes him as having no shirt on, put a shirt on. He was yelling at me that he's going to fucking kill me. Fucking kill my family. I put snow in front of his driveway.
Yes.
Now, this comes out of nowhere, right? He tells you this is like, comes out of nowhere.
Essentially, yes.
And he says he looked at him, and then Kyle gets in his face. And Jason's saying he can't believe what's going on, right?
Is there a specific line that you're asking for?
line 18, page 18.
1818. Thank you, sir.
Yeah, it's okay. Basically says I just kind of look at it. He got in my face even further that I didn't believe him that he's going to fucking kill me and my family.
Yes,
And he says, I don't even know this guy. Right?
correct.
But he goes on to explain something else. What else does he explain?
Is there a specific point?
You approach?
Objection is sustained. May I ask you a question?
Thank you. What he explained to you was that this individual came at him across the driveway, correct?
Yes.
And he came at him unannounced, and there was a mystery to Jason as to why he came at him.
He did mention, having reread 18, about that he did move snow into the front part of his driveway of his neighbor to where his neighbor's grass was, and then he backed up. But as far as the reason why he was coming out at that time, I'm not sure as far as what Jason thought.
But the impression and the clear communication he had with Jason was that he was surprised that such an activity took place.
I believe so, yes.
And when he came out, it was almost immediate that he was threatening Jason, he was threatening Jason's family, and in fact, Jason made it clear to you that his daughter was in the truck with him.
Yes, he indicated that his daughter was in the truck and that the other gentleman had come out and was making threats towards him.
Now, during direct, the prosecutor said that, and you somehow stated that it was a conditional threat.
Yes,
Well, it was a threat, right?
yes,
And it was clear that the individual that was the aggressor would have been KYAL Violette, right?
he's the one that's coming out and making the conditional threat, yes.
He's the one coming out, not only saying things out of his mouth, but literally sticking his nose into Jason's cheek, right?
He got close. The video quality's not good enough to say that his nose touched his cheek from what I saw, but he definitely got close to him, yes.
Well, the jury's going to be able to run those videos over and over.
Yes.
In the deliberation rooms, and they were shown to the jury. And at one point, we counted the number of contacts that Kyle would have had
Okay.
with Jason.
So the video that I saw was the one that was taken from, I believe it was possibly the neighbor's apartment coming from that angle across the driveway. That was the
Right.
video that I watched.
So you weren't able to ascertain what was going on.
I could see that he gets up there, but as far as cheek touching, you can't tell from that video, no.
You could tell that Jason didn't make one step toward Violet, correct?
At which point in time?
The
Sorry.
initial point.
At the initial point, it looked like he had just stood there, yes.
Yeah, he just stood there, and he stood there. And if Jason kind of described it as though he was like paralyzed or just standing still, that would be what you saw, too.
That's what he said in his statement, yes.
Yeah, and that's what was on the video.
Yes.
And also what he said in the statement was that he didn't make a move toward Violet, but Violet made the move toward him.
For the initial interaction, yes.
Yeah, for the initial confrontation.
Yes.
So it's clear, I just want to make this clear, because we're going to be moving down the road here a bit, that the initial aggressor would have been Violet, right?
The individual that came out of his house and started making a threat was KYAL Violette, yes.
Now, you'll agree with me, things can go fast in these situations. It can go like a blur.
It can go fast, yes.
And we're not talking about a situation where somebody had a lot of time to roll over in their mind what to do and how to do it, right?
These are quick decisions, yes.
And we also know the background of Jason Levesque that day was one of an individual that was up over 40 hours, right?
I'm not sure what time exactly he got up, but he said that he had been plowing for over 24 hours.
I told you that he had gotten up, I think, at 8 o'clock the preceding day.
Do you have the page and I can reference?
So he got up, he didn't have any sleep the preceding day from the time he got up.
Okay.
And we saw the video just moments ago of him needing to lay down.
Yes, he has to lay down.
And he also told you that he was tired because of the plowing and the time that he was up so long.
Yes.
And, he was offered food. Did he ever eat anything?
Yes, he ended up eating some chocolate.
A little bit of chocolate?
Yes.
Went like 2 Hershey's Kisses.
I don't remember exactly what he ate, sir.
And that would have been later on during the interrogation.
I'm not sure if he ate them during the interview or the interrogation part of it.
Okay. Now, he also attributed to Violet the fact that Violet had threatened him on more than one occasion at night, right?
In the initial, I believe he said that he had threatened him once, but then he may have repeated the same threat, possibly more than once throughout the night, yes.
Or other things, because he was saying he was screaming at him.
Is there a specific line that you're referencing?
He didn't have any specific recollection that evening, right?
I'm sorry, I don't understand.
Let me ask you, did you ever ask him, as you were moving through the interview, other than the initial threat, were there other threats that he made?
During the initial response, it was more open-ended. I let him just talk, and then there were some follow-up questions. As far as if there was a distinct question, I'm not sure.
But he was very concerned about another individual that was with him that evening, correct?
He was concerned about his daughter, yes.
Yeah, he was concerned about his 19-year-old daughter that was seated in the passenger seat.
Yes.
And in fact, he was concerned that Violette had threatened her as well.
The initial threat had threatened both him and his family, so that would include his daughter, yes.
Right. Now, he stated that, in fact, that his daughter was in essence petrified. Here,
Is there a specific line that you're
I
referencing?
think it's 41. I think it's after you had said, and I don't want to get into. Oh, sorry. Let me rephrase the question, please. Sure. Did he communicate to you that his daughter was afraid that night?
Yes.
Did he communicate to you that his daughter had gotten out of the truck briefly and then got right back in the truck during this altercation?
Is there a specific spot for that you're referencing? I don't recall that.
Okay, let me ask you this. When Violet is coming toward Jason, right, walking towards him, and starts getting nose to nose, is she still in the cab?
He expressed to me, I believe, that she had stayed in the vehicle seatbelted the whole time. But if there's a time that I may be forgetting, if there's a specific spot you want to reference, then I can take a look.
No, that's fine. That's exactly the answer. And he also says that at this point in time, he felt overwhelmed, right?
I believe so, yes.
And that would have been when Violet literally was nose to nose with him.
Correct.
Now, did Jason claim to you that he had a perfect memory of what went on?
I don't believe he ever said that, no.
Let me ask you another general question. Did you ever think that maybe after you got a good night's sleep, you might want to ask me to sit down and have another interview with you?
That would be a conversation down the road, yes.
Did you ever attempt to reconnect with Jason, let's say the next day?
So I'm not sure. I'm trying to remember if that was the next day arraignment. Typically after their arraigned, they would need attorney involved due to constitutional protections. But I didn't speak to him again after that, no.
No, I mean, did you reach out to anybody and say, let's get back together now that Jason's, recovered, gotten some sleep, and we'll go over a statement so we can review it, see if it's accurate. Did you do anything like that?
So I never spoke to him again after that initial interview.
Now, how many different angles of that video did you observe?
To my knowledge, I just remember watching the video from, at least in its entirety, the video from the neighbors. Other detectives might have had the cameras open at some point and watching them, but that's the main one that I saw that night.
Okay, so that's the only angle and the only distance that you were able to ascertain the contact, right?
That's the only video I remember watching that night before I interviewed him or interrogated him on that part.
Now, Jason tried to get it point by point with you. You'd agree with me that in such a situation, shortly after a traumatic event like that, he may actually have been inaccurate in some of the things that he found.
You're asking if he could be inaccurate when he's telling, yes, he could certainly be inaccurate on details.
I mean, when you take in the factors of the recency of the event, the shooting itself, the fact that he hadn't slept for about 40 hours, all these things should be taken into consideration.
Certainly, you got to take into effect people's amount of sleep. You got to take into effect the time, spatial distance between the event and when you're talking to somebody. But again, it was Jason that indicated that he wanted to tell me what had happened that night.
I get it. He said that when he was standing up, that's when he saw Kyle coming.
I believe so, yes.
Yeah, and I think on page 44, you said, so you stood up because you hear him yelling, natural reaction.
Yes,
Jason agrees.
yes.
And then you said, and when you were overwhelmed, kind of describe what your body was doing, how you were thinking, that kind of stuff. And he gave you an answer.
Yes.
What was the answer?
He said, I kind of just froze, like I didn't know what he was going to do. I didn't know if he was going to come up to me. I didn't know what was going to happen.
So at that point in time, he didn't yell back at him or do anything, right?
I don't believe so.
No, yeah. So you never said anything back to him at this point?
Correct. And he said, no, because I didn't want to escalate the situation or, irritate him or whatever you want to use for a word, but make it any worse.
Right. And you were actually asking this question to see what was going through his mind at the time of that contact, right?
Correct.
And at the time of that contact, he says, well, you say, okay, and what does he say?
He says, again, my daughter's in the car. I don't know who this guy is. I still don't know who he is. I don't know what he's capable of. I just didn't want to have any type of problem with him.
And you agree, and then he answers, and he says what?
And obviously he seemed like he was ready to fight.
So that was the impression that you asked him to convey to you with regard to the initial contact, right?
I was asking, yes, what he was thinking, what his emotions, what his body felt like during the initial response, yes.
And the initial response, in essence, was he was frozen, he was shocked, and he thought this guy was ready to fight.
That's what he expressed, yes.
And he was concerned about his belly.
Yes, he also expressed that as well, yes.
He also goes on to indicate to you that at one point he walks away and then turns around.
Who are you referencing in that?
Page 46. And from the top down.
So I ask, is when he turned around and how far away is that at that point? I'm not familiar with where and Mr. Levesque says, yeah, no problem, maybe 15 feet. So then I ask, okay, and so he turns around and how's his body? What's he saying? That kind of stuff.
Okay, so you'd agree with me, if you look at the video, this beginning of the contact to the end of the contact with the last shot fired is about a total of 11 seconds.
It's fairly quick, yes.
And he says, what does he say when you say, what's he saying? That kind of stuff? What's his name? Sorry.
Yes. Mr. Levesque says he's still very agitated. He's got his fists. He's very animated in how he's yelling. And just, he's going to fucking kill me and my family for moving snow, I guess.
Now, this whole conditional threat, he didn't say that when he turned around and said that it was a conditional threat. He said, he's going to fucking kill me and my family for moving snow, I guess. Right? So Kyle didn't say for moving snow, I guess, right?
He's explaining what happened. I don't know if he's actually saying verbatim like he did previously as far as what the threat was. I think he's paraphrasing more, but certainly he does say, and I can read it again. He's still very agitated. He's got his fists. He's very animated in how he's yelling, and just he's going to fucking kill me and my family for moving snow, I guess.
Now, the prosecutor asked you whether you heard anything on the video, any yelling or anything like that, right?
I believe so, yes.
I mean, did you guys do any kind of a scientific, test out there to determine whether or not you could even hear any yelling from that spot?
So no, again, my involvement for this was the arrest and assisting with some of the follow-up. That was my involvement with this case.
Okay. You know if any kind of a decibel reading was taken at or around 41 Summer Street at the location where yelling was claimed to have taken place? Not from the house, not from individuals running outside, but from that very spot.
Sure, I'm not sure how if someone's yelling, I don't see how that's relevant because people's voices could be higher distances. I'm not, depending on where they are, I don't see the relevance of it, but.
Well, I don't know. I mean, it was asked on direct. Sure, I didn't ask anything about decibel readings. About, did you hear yelling? Remember that on direct?
You asked what should you best answer the question.
Sure, I don't remember it. I believe he asked about yelling, but I'm not positive, but I don't recall anything about decibels.
I'd say, let's forget the decibels.
Yeah, we have a question.
Let's take the decibels and throw that out. Okay. Recall being asked about, did you hear any yelling?
Is there a specific page? Okay, yeah, no, I don't recall.
Now, you agree that you said to him, and I'll guide you on this, it's the page that got cut off, I think, without the number. Might be 47. Basically, Jason was focused on Kyle, right? I'll give you a,
He talks about, there's a female as well.
yeah, he hears a female yelling, and that may very well have been Kyle's girlfriend that was yelling in that video.
Oh, presumably, yes.
Now, let me ask you something, okay? I'm gonna go through this checklist with you because I want to make sure that we don't paint Jason in some corner where he's trying to avoid answering questions. He's the guy that waited in his driveway for the police to show up, right?
From what I've heard, after asking if his daughter, if he should run, yes, he waited in the driveway.
He asked whether, I mean, you don't know, there were many other things, we'll get to that, that may of course been discussed in the cab of that truck. But he didn't run, right?
No, he didn't run.
Not only did he not run, he preserved the firearm and made it safe so that when police showed up, right, it would be there for them in plain view in the cab of his truck. Right?
Yes, is what he told me.
When the officers arrived, he made sure that they knew he would be coming with them without resistance. In other words, he exited the truck with his hands up. Right?
That would be a question for the other officers. I arrived on the scene after he was already in handcuffs.
Well, did you describe him as a cooperative individual when you were on
Yeah.
your way to the station?
Yes, he was cooperative with me the entire time, yes.
And this cooperative individual, in fact, did everything you asked him to do. He didn't resist one iota.
Not that I recall, no.
Not at all. You got no reports of that at all, right?
I don't recall him not being cooperative. He was cooperative throughout.
Right. He told you where everything was. He said you could search his truck, right?
Yes,
He said you could seize his video equipment and videos from his home.
yes,
He, when given the Miranda rights and the constitutional rights afforded to him, made a decision that he was going to speak with you, right?
yes,
He was cooperative during the interrogation.
yes.
I mean, he was basically sitting there as long as you want him to be there.
He was willing to answer my questions and talk to me for as long as I had questions up until that point, yes. He never
You-
asked to stop or anything like that.
You're the guy that terminated the interview, not him. He didn't say, I've had enough, I don't want to talk to you.
No, he never made a statement like that. As far as the termination, it was more, he was going downstairs to get fingerprinted and processed. I believe is how the interview kind of concluded.
Now, this is, the backdrop of this is that you've got the guy that the jury saw in the video, but later on, about an hour later, in fact, you start asking him questions again, like, can we go over what happened that night, right?
Yes, I would ask the same question a number of times in a number of different ways. Yes,
And you wanted to swab his hands?
yes.
Can you tell the jury what that's all about?
So typically we'll do GSR kits. It's a gunshot residue kit. Basically just shows if you're in the presence of a firearm discharge or the equivalent. One of the questions on there is if you handled fireworks, because there might be some similar kind of chemicals or materials that you might handle that are similar in both.
Now, about an hour in, as you're going through the swabbing process, and this is after what the jury already saw, he tells you guys that he's not feeling so good, right?
Do you have a page reference?
79, 25.
Yes. I believe I was out of the room at that time.
Was there a trash barrel or something offered? In case he vomited?
Again, I can look at the transcript and say that I was out of the room when that conversation occurred. That was with Detective Flathers.
At that point in time, though, does he express that he's overwhelmed and tired?
So he says, I don't feel so good, just a second. And Flathers asks, do you want a trash barrel or something? And Levesque says, no, I want to lay down too. And then I come back. And then he goes on when I get back in the room saying, just give me a second. I think I'm just overtired and overwhelmed.
Yeah, that's when Flathers says, do you think you want an ambulance?
Yes.
And he responds, I'm overtired and I'm overwhelmed.
Yes.
This is about an hour or so after what the jury just saw in that day.
So I returned with the swap kit into the room at 11:42 p.m.
About an hour. And he says there's a lot going on, right?
Yes.
And he says, I'm trying to stay calm and focused, but sometimes I just get, I don't know. And I guess your partner says, like a little rush. And the back says, yeah. Hot, cold, I don't know. And I apologize if I stink. I feel like I just smell awful.
Yes.
And that's because he had been working all day, hadn't had the opportunity to clean up.
Correct.
And then you go through the hand swab, correct?
Yes.
How long of a process is that?
It's relatively quick. They have basically almost like the kid stamps where you're just stamping around different portions of the hands and then filling out a page that kind of asks them a few questions as well. But it's not a long process.
And he was cooperative through that, right?
Yes.
And you're trying to understand exactly what's going on. And he's telling you that there's some gray area with regard to telling you. That's on page 117, lines 23, 24, 25.
One moment. So he says, right, so I don't know if maybe there's a gray area and that's what I think happened. And I just don't remember, I don't know.
But he's willing to stick around and continue to answer questions. And this is when you're actually asking him to rethink some of the things he's already said.
I'm asking, yes, if he basically as a tactic to ask him if, maybe the first story of events, you were just still in shock, so you weren't trying to mislead or lie to us or anything like that.
Right. In fact, you tell him that. He's saying, I'm being completely honest with you. And you say, maybe the first story of events, like maybe you were just still in shock. And he goes, yes, right, correct.
Yes, as part of an interrogation tactic, you can offer someone an opportunity to save face. If you tell somebody you're lying, sometimes that shuts somebody down and they won't talk to you anymore. So you give them an opportunity, a way out to still be able to communicate, still be able to talk to you without basically giving them no alternative.
Yeah, I mean, that's lovely, but that alternative was an offer to him when he had gotten a good night's sleep, right?
He had indicated that he still wanted to talk. So as far as asking if he wanted sleep, I didn't ask him if he wanted to stop to have sleep at that point in time. We were in the middle of the interrogation or beginning the interrogation at that point.
Inviting him to take a look at his statement and make any corrections.
Yeah, so he did ask me if he could review his prior statement, and there's a reason why, again, we do these spatial gaps. It's harder to remember all the lies that you're telling if there's a little bit of gap in between. Also, again, asking questions different ways. There's some benefits of having that space.
Is it a good tactic to interview and interrogate people that are sleep deprived?
Again, Mr. Levesque indicated that he was willing to do the interview. There's no obligation to do so. I read him his Miranda rights. It was his decision to speak with me.
Yeah, I'm glad that's the answer you're giving me, but is it a good tactic to interview people that are sleep deprived? Is that part of the tactics that you guys have?
As far as that, we don't typically go out seeking people that are sleep deprived. It's just the circumstances of events. He had been out plowing that whole night. We don't choose that, that he was out that whole day. That was the hand that was given to us, so that's what we had to work with.
But that's a hand that you can reshuffle, right? That's a hand where you can say, hey, we'll come back at 8 o'clock in the morning and talk. We'll come back at 10 o'clock in the morning.
Again, no one was forcing Mr. Levesque to talk to us.
Nobody's forcing him. But would you take a neutral witness and say, hey, I know you haven't slept 40 hours, but I want you to give me a statement? Or would you say, would you like to have some sleep? And then give me an accurate statement. statement?
Again, if he's willing to talk to us that night, we're trying to figure out what had happened that night. We're going to talk to him. If at any point in time he indicated to me that he would rather speak to me the next day, certainly that would be something that we could revisit.
You saw the guy nodding off right in front of you.
So even during the daytime, during arrests, we do have people nodding off. We have people, in booking that could be lying down. It's not uncommon for people to lie down on benches just during day shift during the middle of the day. So that's not super uncommon.
It's super uncommon. But the jury got to see what he looked like. He's bedraggled, isn't he?
They certainly got to see what he looked like. What was the question? Sorry, I missed the last part.
I know that you may say it's not super uncommon, but are you saying that it's a good tactic to interview witnesses to get an accurate story when they have not had slept for 40 hours? Is that a good environment to get an accurate statement? Honestly.
It's still fresh in his memory. I think there's still some benefit of talking to him then. Certainly, again, revisiting once you get a full night's sleep, you might be able to get some additional information. But again, at that point, he would have been arraigned.
Did arm do that? No way. There's no way. Absolutely no way. I've been waiting for a long time to do this. I've had thunderstorms and hail since 6:30 this morning. It's time to go ahead and just get it going. Sorry about the noise. I'm going to try to edit it out. Now I kicked the camera stand, so let's move that. Don't know if I can do it right here. it broke the whole side off. It didn't break any of the diffusers. Didn't break the reverse light. Did the arm do that? No way. There's no way. Absolutely no way. That is 9 pounds of stainless steel with fiber reinforced rubber, 1 millimeter thick, to mimic skin. It's tougher than skin. I didn't want anything that was going to hamper the destruction of the taillight. My hands are on fire, literally. But look at this. The whole passenger side of the taillight is busted off. The whole, everything. It's split right where the chrome piece is on the side and tore that whole piece off. If that was somebody's arm, it would be broken. I guarantee it. This thing was so solid as I was hitting it. It was actually reverbing through my hand, through the pole into my hands. But there is not a single diffuser. That one's pushed out when I got the very side of it. Absolutely no way. Look at the arm. I put that thin foam on it just to see what the marks would look like. Now I know there's going to be the naysayers. Oh, that looks just like the injury. No, it doesn't, because the car was moving 26 miles an hour. So, car was moving at 26 miles an hour, so they say. Sorry about the wind noise. Hopefully I'll get this edited out. If I don't, at least it'll be quieter. When a car is traveling at that speed, if his arm would have been sticking out, I hit it across the whole front. That would be the only way that the taillight would have been busted all the way across. If it would have just glanced his arm, it would have taken the whole side of it off. This is the whole side, the housing, everything. That didn't happen. It wasn't a glancing blow, as Hank says. He couldn't have had his arm stretched out right, and it hit the taillight. With the car moving at that velocity, that much weight, when the arm would hit it, it would spread the skin out for a second, And as the car's going past, it would pull it this way. So the cuts and scratches that would result on an arm would be up and down the arm, not horizontally, or not going from back to front, and the elbow having like bite marks. It's just not possible. I don't care what anybody says. Taillight did not strike a person. Now, I knew the taillight would break with enough force with repeated blows. So every time I struck it, it was weakening the taillight. But those first few blows, it didn't break. The taillight's designed for that. It's going to soak up some energy, and it's going to disperse it. Now, had the car been going 50, 60 miles an hour and it hit John's arm, maybe that would have spun him around, but his whole arm would have been probably broken off. But a 25-mile-an-hour hit is not that fast. It's enough to hurt you, daze you a little bit, but throw you 30 feet into a yard, tumbling and hitting your head on some kind of magical hard as a rock snow. No, never in a million years. Not in a million years. In fact, the next time you're in your car and you get off of an expressway and pull into your neighborhood, take the time to roll down your window and look outside and look how slow that really is. It's enough to kill you. If a car hits you head on straight in the front or far enough to the side where you're still in front of a car, yeah, it could kill you. Most of the time it doesn't. Sometimes nothing happens. Sometimes it could knock you to the ground and you could get a couple of scratches and a bruise, but that's another thing. There is no bruises. A hit like that on an arm, strong enough to tear the whole side of the taillight off, which the LED is right there that for the top and the bottom. That would have cut his arm going across like this because the car is traveling past. The arm's not going to just hit it and bounce off like it's a bouncy ball. The arm would have hit it, absorbed energy into the taillight, and as it was doing that, it would have pulled. Furthermore, it would have tore the whole side off of it. None of these are broke. None of the diffusers are broke. The taillight thing's not broke. Or the taillight thing. It's got a crack in it. There's nothing missing on it. The whole side of that light is gone. That much force, it broke the whole side of the housing, everything.
Were you able to ask details that he was responsive, questions about details that he was responsive to?
Yes, and he told me in a gist that he had continued to walk away holding his abdomen.
What? Concerning, some of these questions, follow-up questions about details, did that include asking him to do a sketch?
Yes.
Your Honor, may I approach? To show you what's been now marked as a state's full exhibit 27 and 28 and ask whether you can identify that.
So these look like copies of the drawings that I asked Mr. Levesque to draw when the first shot went off and then the second round of shots that went off.
And so you've labeled these first and second. Is that what you mean by first round of shots, second round of shots?
They're labeled first and second. That might be his handwriting. I might have asked him to label it.
That's right.
Yes.
And so can you just, for the record, state to the jury where Mr. Levesque claimed he was standing, to describe it by other aspects of the drawing, during the second round, and where he claimed I was standing?
Near the end of the interview, yes, he put his head down on the table.
He's exhibiting exhaustion, isn't he?
Yes.
He's not saying he wouldn't talk to you again. In fact, he kind of dangled it out there.
Yes, I indicated that he could reapproach us and talk to us again. If he's tired, this might be the only opportunity that we have to speak with him. Once this hits the news, once he's arraigned, once he has an attorney, there's a very low likelihood that we're ever going to get another chance to speak with him. So yes, I did speak with him.
I know he did. And again, he made no invitations afterwards.
Again, it was said right there, the line you had me read, that this wasn't the be-all end-all. If he would like to speak with us again, certainly we can reapproach.
Or if you would like to speak with him.
If there's other questions, yes, that we had.
And again, you didn't ever send out that invitation.
I did not know.
Now, he's repeated to you on a number of occasions that he's trying to give you the best description that he can. I mean, I can go through a number of pages, but I'll just randomly pick them out. Page 117, starting at line 11.
So Mr. Levesque says, yeah, I've been completely honest with you about the whole thing to the best of my knowledge, to the best of what I can remember. That being said, I don't remember correctly, or I'm not giving the right account of it, but it's hard to try and give the best description of it if, you know what I mean? Like, to break it down slowly like we did.
Right. And you said, yeah, like I said, he says, I'm being completely honest with you. This is on 118. You say maybe the first story of events, like maybe you just still been shot, right?
Yes, again, it's offering that safe face opportunity, that maybe he wasn't telling the truth the first time, but here's your opportunity to tell us what had happened.
Well, maybe the truth is a little hard, don't you think, detective? Maybe he wasn't being completely accurate because he was exhausted too. Right?
Tiredness could certainly have an impact, yes.
And in fact, you told him, so you weren't trying to mislead us or lie to us or anything like that. And Levesque shakes his head no. In fact, you continue with him and you say, I don't think, again, I think you're intentionally lying to us or anything like that. I think it was just, an honest mistake, that first version of events, and Levesque goes right. And he sticks with you and he says, let's go through it again, basically, right? I mean, he's telling you, take my video. He brings it up to you, right? On 118.
So on 118, he goes, if I wouldn't go, hey, I have some video of, and again, the whole situation, like.
Yeah. He's trying, right?
Trying to what, sorry?
Be honest and complete with it. It's always speculative. He's telling you that, and you're telling him that on page 119. What his claims are concerning his honesty versus his brother's being. May I ask you next question? You told him that the most important thing in his life was his daughter, right?
Something to that effect, yes.
And he agreed, right?
Yes,
And this is the same daughter that he had articulated concerns about during this whole interaction.
yes,
Same one he picked up that evening and the same one that was in the cab while they were being approached by Kyle Violet.
yes. While he was being approached by Kyle Violet, she was in the vehicle, yes.
Was there other procedures that took place that he was cooperative with that night? I'll go through a couple. Fingerprinting?
Again, I didn't do the fingerprinting, so I'm assuming he was cooperative, but that's only an assumption. I can't tell you that for certain.
Right. But there were no reports that he had any problems with any of the police officers that he,
I never heard of him having an issue with fingerprinting.
I could have 1 second. Yes. Thank you. Counsel, please rise. You had been asked about tactics for interviewing, interrogating people. What was the objective of any tactic that you use?
To receive an accurate, honest answer.
And is it included in your tactic to determine whether or not somebody's being straight up and honest?
There's definitely some consideration. You're interpreting what they say and trying to determine whether they're being honest, yes.
Well, let me put it this way. Would you lay out all the evidence in an investigation before you ask somebody questions about their claims concerning events?
No, it's actually better to let people continually tell a lie. That way you have more foundation to basically cross some of the statements that they're making to determine what's accurate, what's not.
Similarly, do you think it's a good tactic to get honest and complete answers and to test credibility by affording a suspect an opportunity to, for example, consult with other people, review evidence that they may have available to them before approaching them to question them?
No, with that being said, though, certainly give them the opportunity if they want to confer with an attorney or a lawyer. But as far as if they're willing to talk to us, we're going to ask the questions and try and get the accurate information, yes.
And in fact, we referred to Miranda. Did you give him an opportunity to consult with a lawyer before talking to you?
Yes.
And did he waive that right and agree to talk to you?
Yes.
Concerning his fatigue and whatnot, was he accurate, for instance, in describing where these events occurred?
Yes.
Was he accurate in describing what he was doing, his activity prior to these events?
Yes.
Was he accurate in describing certain very specific details, like Kyle putting on a hoodie that was green or camo walking out of his driveway?
Yes.
And was he accurate in terms of disclosing to you how many rounds he shot into Kyle Violette's body?
He was accurate on how many shots he fired.
There were some other things, though. Attorney Sisti asked you about a section where you're saying, I believe you're not lying to me. Were you sharing your opinion about his credibility with him, or was that a tactic?
Again, it's a tactic. My opinions on the matter are kind of irrelevant. We're trying to figure out, the truth of the matter. So giving him, again, outs, giving him some belief that we're believing what he's saying is another tactic, basically, that you can use.
And that point at about 151 in the transcript where Attorney Sisti was asking you questions where you're sharing, I don't think you were trying to lie to us. Is that after you had disclosed that you actually had seen and obtained a video of this scene?
I believe that was after we referenced the video. I'd have to see what page I talked to the. 1 second. Presumably saying I was near the end of the interview or interrogation, rather, I would say yes.
Can you take a look at approximately 99, line 24, where it appears to be the first time you actually call him out? Say, would it surprise you that you're actually moving towards him after he claimed that he wasn't?
Yeah, so I asked, would it surprise you if you had moved towards him? And he asked, would it surprise me? And I responded, yeah. And he goes, and then I go, or to your recollection, you were pretty stationary with your feet. And Mr. Levesque responds, I don't believe I did.
And at that point, when you say, would it surprise you that you were actually moving towards you, is it at that point about that you had an opportunity to review the first video?
Yes, I would have had, let me see when the break was. Do you know what page that I stepped out of the room?
I do.
Context.
I'm sorry, with our current technical shutdown, I was unable to print out that section. But when you refer to would it surprise you, how would you know whether he was walking forward or not?
Yeah, so I mean, that's an indicator that I likely had watched the video at that point, if I'm referencing that in that kind of language.
Attorney Sisti pointed out something at about page 90, whatever, that the defendant brought up cameras. But can you turn to page 66?
Yes.
From 30 pages earlier. Page 66, line 18. Is that you asking, do you have any cameras that can cover any of the interaction tonight?
Yes.
Is that you bringing up potential video footage of this evening in the first instance?
Yes.
Let's talk then about some of the details that came up here. The Attorney Sisti had suggested, frankly, that Mr. Levesque didn't have any idea what was going on when the victim Kyle approached. Can I direct your attention to page 18, line 8?
Okay.
I think at one point you had started to share this information that Jason Levesque had acknowledged. Can you read what it is he said he had done just prior to Kyle coming out?
Yes, so Mr. Levesque says, I drive, started moving the snow. I had moved the snow into the front part of the driveway of my neighbor to where my neighbor's grass is, and I backed up. And I'd gotten out to put it in four-wheel drive. It's the old style manual hubs. You have to lock them in.
Okay. So he characterized where he had just put snow and that he was continuing this job of moving snow from his driveway, like back pulling it into the street.
Correct.
We don't have any, again, I don't want to nickel and dime this, but we don't have any idea where he was going to put all the snow that came out from his driveway.
No.
And this, we talked about it, but this conditional threat, I want to be clear on this point. Can you had confirmed earlier that Jason Levesque stated this was, quote, in his own word, verbatim and exactly what was said. That's at page 36, line 18 to 20. Can you repeat that?
Yes, sir. So Mr. Levesque says, yeah, he said, if you put that fucking snow at the end of my fucking driveway, I'm going to fucking kill you and kill your fucking family.
Concerning, you revisited that, and did that ever change in terms of him predicating his threat with moving the snow again in front of his driveway or his house or his property?
It's my understanding the threats all the time were regarding the snow removal.
And at any point, did, I get, these words, and your family, at any point, did Jason Levesque claim it concerned specifically, and I know that daughter's included in a family, ever specifically mention his daughter as part of the threat?
Not that the threat was specific to his daughter, it was to your family. He did bring up, or we did discuss his daughter at one point during the interview, but the threat itself was your family.
And did Jason Levesque ever claim that Kyle focused his attention on Kira in the cab of that truck?
He did not.
Did he ever claim that Kyle Violette was even aware that Kira was in the cab of the truck?
I don't believe he brought that up, no.
This description of him being nose to nose and making this threat hit his face, and he was overwhelmed. Is that the point that Jason Levesque shot Kyle Violette?
No, Kyle had walked away from Mr. Levesque prior to that.
And after he walked away, page 43, line 16, can you share with us how Mr. Levesque characterized the continuing, I guess, conversation?
Mr. Levesque says, I don't know if he repeated it again before he started walking off. And then for some reason, he stopped and turned around and said, you don't fucking believe me? And he came back at me again.
And his claim about how far Mr. Violette came, does he share that? Is that where he's saying he's within 3 to 5 feet from him?
Possibly at one part of the interview, not
Okay.
close temporarily to that statement.
The questions have been about, accuracy. We had already talked on our first direct that he had claimed he shot him, didn't know whether he hit him the first time because he only flinched.
That's what he said, yes.
Okay. Did he appear, sort of overwhelmed by fatigue when he was making that statement to you? Or did you ask for details surrounding that event?
No, I asked for details for most of the interactions that he had with Kyle that night. So go into further detail once he made a statement. I would clarify, ask for more detail.
And likewise, when he made claims that he put 5 more rounds into Mr. Violette and Mr. Violette merely turned and walked away, were you able to ask details that he was responsive, questions about details that he was responsive to?
Yes, and he told me in a gist that he had continued to walk away holding his abdomen.
What? Concerning, some of these questions, follow-up questions about details, did that include asking him to do a sketch?
Yes.
Your Honor, may approach. Yeah, you can go on his folder. Good strike. 27, 28, or what was it? To show you what's been now marked as a state's full exhibit 27 and 28, and ask whether you can identify that.
So these look like copies of the drawings that I asked Mr. Levesque to draw when the first shot went off and then the second round of shots that went off.
And so you've labeled these first and second. Is that what you mean by first round of shots, second round of shots?
They're labeled first and second. That might be his handwriting. I might have asked him to label it.
That's what I mean.
Yes.
And so can you just, for the record, state to the jury where Mr. Levesque claimed he was standing, to describe it by other aspects of the drawing, during the second round, and where he claimed Kyle was standing?
Yeah, so based on the drawing, it looks like Mr. Levesque is towards the driver's side front, well, it's the side, but it's near the front tire on the driver's side. And then Mr. Violette is closer to 41, like halfway in the drawing there.
And, the defense attorney, Mr. Attorney Sisti, had asked you about this area where, Jason, after you said, hey, look, I've seen some video, maybe you're mistaken, maybe there's some gray area here. Is it your recollection that any of those mistakes, that Kyle remained standing, that he didn't react to being shot the first time, any of those mistakes sort of favor a claim of self-defense? I'll withdraw. Sir, those are my questions. I appreciate it.
Based on the redress.
I sure do, Judge, and I'd like to approach this.
Sure.
To page 25.
Thank you. Yes.
Right, and that's why you knew to ask him about cameras, see page 66, right? Line 15.
Yes, I asked him about the outside cameras.
Yes, you asked him. You mentioned from the prior event from 2 months ago, there were cameras. Right?
Yes.
Okay, so you didn't come up with this request out of thin air. He already gave up that he had video cameras much earlier on in this interview.
Yes.
Now, would you agree with me that Jason was accurate when he claimed that Violette initiated the contact on April 4th?
He's the one that walked across the driveway yelling out to Jason, yes.
Okay, so that's a yes. And would you agree with me that Violette stuck his face into Jason's face?
I would agree with you that he got very close to him based on the video that I saw, yes.
Would you agree with me that Violette appeared to be agitated?
Yes.
Would you agree with me that Jason said that after the event, he parked the truck, stayed there and waited for police response?
Yes.
Would you agree with me that he left the firearm and he left it safe on the dashboard of the truck?
I would agree with you that he left the firearm in the truck.
Now, he never told you that he was able to specifically count the number of rounds that came out of the firearm. It's just that the magazine was empty, right?
He told me at one point that he had 5 + 1 and that he emptied the magazine.
Right. So it's a matter of doing math, not specific recollection of each trigger pull. Correct.
I don't recall if he ever specifically said. I'd have to look. If there's a page that you're referencing, that would be helpful.
I don't have a page.
Okay.
Now, you know, Kara Violette was a witness too, right? I know his daughter was a witness.
Yes.
She was interviewed, right?
Not by myself.
No. But do you know whether or not she was sleep deprived or anything like Jason was?
I do not.
Do you know what she claimed to hear? I'm not asking for the answer. I'm asking whether he knows what she heard. The answer is yes or no. You do understand that Kara is a witness as well, correct?
Yes.
And again, you never approached her and interviewed her? I'm just asking whether he did that. And I looked at your entire transcript. Did you ask Jason if there were any other threats that night? Any other threats, other than the ones that he had related?
I don't recall.
Did you ask him, instead of speculating about the snow, did you ask him where he was going to plow the snow?
he had brought up as far as the initial where he moved snow, as far as he said he was going to back drag the driveway. I didn't ask him where that snow was going to go. No.
No, because wasn't that a big subject of contention that the snow was going to go over to Violette's driveway?
That's the initial reason why Violet came out.
And that's a question you never even asked Jason as to where he was going to plow the snow.
That doesn't necessarily change as far as
Sir, sir.
Can I answer?
No, he can't. He's not being responsive.
Allow me to answer the question. So if the objection's overruled, you can answer the question.
Answer the question.
Can you ask the question?
Was, did you ever ask him where the snow was going to go? Correct?
Correct.
Yes, no.
No.
Thank you. Anything further?
Just very briefly.
All right, I will ask some last two councilors. I understand, very short.
Thank you.
Reading correct.
You would ask for a page number concerning, whether Jason Levesque was aware of how many times he discharged the firearm. I'm going to ask you to look at page 54, line 16. Question.
So I asked him, okay, do you remember how many times the trigger was pulled? And he responded, yeah, 6 times.
Any specific questions?
I will go right to it, Judge. Did you ask him how he knew?
So I asked him after that, okay, so you fully emptied the clip at that point? And he nodded his head in affirmative. I can't answer that question. I don't know what was on his mind. Thank you, Your Honor.
Given that it's 4:05 at this point, I think we're going to end for the evening. So we'll leave you in a bit of suspense, and then we'll see.
Hey there, thanks for stopping in. We hope you will join us again. We all look forward to next time. We get to talk about true crime. Clues. Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule and the defense rests. Our true crime family is great. All types of topics we debate. Smash that like and ring that bell. Hit subscribe, you might as well.